Good morning, Your Honor.
Good morning, Officer Milton. I hope you're well today.
Yes, sir. Thank you for asking. Um, let's start with Miss position number 8, Miss Blackwell, Shanita Blackwell.
Okay. And let's see, do we have the public defenders on the line?
Good morning, Your Honor.
Good,
I'm
good,
Blackwell.
good morning, Mr. Ty. Let's see, are you representing Miss Blackwell today?
Yes.
Okay, and it's going to be a negotiated plea, is that correct?
Yes, Your Honor.
Thank you. Good morning, Ms. Blackwell. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, Ms. Blackwell? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, you can place your hand down. Thank you, ma'am. Yes, Ms. Falk.
Yes, Your Honor. The state's recommendation on this case is 12 months served, 32 days, credit for time served 16 days from June 24th, 2024 to today, balance suspended, stay away from 351 Hill Street, Southeast Atlanta, no further contact with Maya Hunt. We have had a contact with Ms. Hunt. She is in agreement with the plea offer. At this time, we would like to sound for Maya Hunt.
If Ms. Hunt is on the line and would like to address the court, now is your opportunity.
And Your Honor, we do ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea.
We do so stipulate.
Anything further, Mr. Ty?
As I understand, she wouldn't have to report to probation. The balance is suspended, so we don't have any issues as long as that's the case.
Okay, it's my understanding that that's the case. If nothing further, Ms. Blackwell, it's my understanding that in case 24 CR 0041111B, you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir. I understand.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Ms. Blackwell. Good luck to you, ma'am.
All right. Thank you.
You're welcome.
Thank you.
Next, we have position 42 and 43, Mick Wilcox.
This is also a negotiated plea, is that correct?
No, Your Honor.
It's a non-negotiated plea, I'm sorry.
Yes, Your Honor, I would like to make a bond argument for her. Well, Your Honor, there's position 42. She's not currently being held on those charges. So, and it is a global recommendation. So we're not able to move forward with a plea.
Okay, so do I need to arraign her this morning prior to having a bond hearing, or will you file a waiver?
I'll file a waiver.
Okay. And so 42 is not an issue at the present time, but 43, you're requesting a bond modification, is that correct?
Yes, Your Honor.
Okay. Let's see, who do we have on? Let me get the history first. Do we have anyone on from pretrial this morning? I don't see pretrial with this. Let's see, Ms. Falk, do you have the history for me, and can you give me the facts?
I do, Your Honor. So there is one cycle out of Jasper County, and I'm not sure what state that is. It is a public disorderly conduct from 2017. She also has a total in Georgia of, let's see, 23 cycles. So she has a June 5th FTA on a felony case. A simple battery family violence, June 5th, driving while license suspended or revoked, February 28th of 2024. Battery driving while license suspended out of Union City Municipal Court. That was July of 2023. All of these are arrests that have no disposition at this time. Failure to appear, November 29th of 2022. Probation violation in July 25th of 2022. Theft by shoplifting arrest, June 19th of 2022. Theft by receiving stolen property, driving while license suspended, June 19th of 2022. She has a August 26, 2021 theft by taking. Again, all of these are arrests. August 23rd of 2021, failure to appear out of Fayette County. She then has a 12-month sentence for driving without a valid license on January 16th of 2020. Let's see. Probation violation, June 20th of 2019. Arrest for driving without license, with its suspended license, May 30th of 2019. Willful obstruction of law enforcement officers. She was sentenced on that August 25th of 2021, received 12 months probation. Failure to appear, May 5th of 2019, was sentenced to 12 months probation. Let's see. And that takes us to an arrest on February 21st, 2019 for driving with a suspended license. And then that takes us all the way back to 2009 at that point.
Okay. And what's the current bonds on position 43, the simple battery and criminal trespass?
So her current bond is, let's see, she has a failure to appear that she's actually being held on currently without bond, and that's a felony failure to appear. She has a $4,500 surety bond on the criminal trespass and simple battery family violence that was issued by Judge Mincy on June 6th of 2024. Obviously, I'm speculating, but that may have been in large part due to the fact that she had previous FTAs and is actually currently being held on an FTA. She also has a companion case. Just pull up the companion case number. And that case is currently is our simple battery, reckless driving, and driving without a license or license suspended. So this incident happened June 4th of 2024. It happened at 6335 Emerald Point Circle in South Fulton. The victim, Miss Tracy McGinty, stated she had been hit and attacked by her daughter, Takilia Lasha Smith Wilcox. She stated that she refused to be hit by her own daughter and disrespected in her own home. And she stated that earlier that day, the defendant asked if she could go to the store, and she started crying, saying that her son hit her and stole $5. She stated that she and the defendant got into a verbal argument, so they never actually made it out of the driveway. At that point, the defendant hit her and in the vehicle for no reason. She said at that point she went and called 911, and when she got off the phone, the defendant knocked the lamp down, jumped on her on the floor near the front door, and then proceeded to hit her with a closed fist in the back. She stated her grandson, KW, actually pulled his mother off of her to stop the defendant from continuing to hit her. She also stated that the defendant broke her lamp, mirror, and reading glasses. And the officers did see a lamp and mirror on the floor when they came into the home. The juvenile KW stated that his mother came into the room accusing him of stealing $5, throwing his belongings off the dresser, and then she went into her mother's room. At that point, he heard his mother and his grandmother tussling. He said when he went downstairs, he saw his mother on top of his grandmother hitting her with a closed fist, and so he pulled her off of his grandmother. And that is the state's recommendation on this case was in large part due to the fact that this defendant has a history, repeated failure to appears, repeated probation violations. There's also the simple battery that is currently pending in the other case where she assaulted a young woman by the name of Tanika Aston by spraying her with pepper spray. So there is a history here that was very concerning, and that is the reason for the state's recommendation.
Thank you, Ms. Falk. Ms. Atai?
Yes, Your Honor, my client is 36 years old. She is the mother to a minor child, a 17-year-old son. She is a Georgia resident. I understand she has FTAs, Your Honor, but from what I've seen, she's very organized. She states that she never received notice for the FTA that she's currently being held on, and she will be here until her FTA hearing on July 26th. I have spoken with and Your Honor, in position 42, that case, she firmly denies the allegations and states that she was defending herself. And on this position 43, I have spoken with her mother, Miss McGinty, and she states that she loves her daughter very much. She doesn't want her to be in jail any longer. She has been in jail for 35 days because she's unable to pay the $4,500 bond. In position 43, the state is asking for no further contact, but her mother stated that she would be on the call today and that she does want contact with her daughter. She doesn't want to live together, so the stay away is fine. But I would ask for no violent contact and to sound for Miss McGinty at the end of this. Your Honor, I didn't want to address position 42 as far as the plea because I feel that it's unfair to offer a global recommendation and put in a case that she's not being held on. She's being held only on position 43. She has been in custody for 35 days. While in custody, she has been actively involved in any and all programs that are offered at the jail. She's actually completed 9 hours of community service through Full Circle 360 of America. We are working with Tanika Davis and our social workers and are confident that by the time, hopefully that she can be released after the FTA hearing on July 26th, that she will have placement at Mary Hall, Freedom House. And we have made that referral and they just need a phone interview. So I am asking for a $4,500 signature bond through pretrial services on position 43 that she has already been held for 35 days and will be here even longer than that for the FTA hearing on July 26th.
And Your Honor, I will add that we did have contact with Miss Wilcox last month. She stated that they have been in verbal altercations in the past, but this is the first time it turned physical. She also told us at that time she wants no contact and wants the defendant to leave her residence and stay away, and that she would need a one-time escort to retrieve her belongings, which is why the state recommended no further contact instead of no further violent contact was based on the wishes of the victim at that time. We also would like to sound for Miss Tracy McGinty if that position has changed. I will add that in looking at the cases, I did omit a theft by shoplifting from 2022. It's 2022 CR 004284D. It looks like that was also a failure to appear on August 8th of 2022 in front of Judge Edline. So we will be contacting the jail to make sure that she is held on that failure to appear as well, since it appears there's both a felony failure to appear and a misdemeanor failure to appear that she currently has in Fulton County.
Your Honor, I mean, she's been here for 35 days. I mean, adding I'll take care of I'll find out about the FTA in Edline's courtroom, but I mean, she's been here for 35 days, so. And Your Honor, I spoke with the complaining witness yesterday, not a month ago, and she did tell me that she loves her daughter. She does want contact with her. She told me that she would be on the call. My client has not spoken with the 17-year-old child in 35 days because she is abiding by what the court has stated that she shouldn't have any contact in the meantime with her mother and has not been able to speak with her 17-year-old son. and has been held for 35 days. So I'm just asking for a $4,500 signature bond through pretrial services. She will have placement. She will be working with the public defender's office to ensure that she doesn't have any more failure to appears. We have a good address for her mail and nothing further for this client.
If Ms. McGinty's on the line and wishes to address the court, now is your opportunity to do so. Doesn't appear so. I'm concerned about her failure to appear, Ms. Atai. I know that she is will be in custody for a good bit longer. If she wants to take a plea at some point on position number, since she's not being held on position number 42 and wants to take a plea on position number 43 at some point, I'm willing to entertain that also. But as far as modification of the bond at this time, given her history, I'm not so inclined to do so. If you want to be able to speak with her, given that she's going to be in custody for a while, and put her back on an SAP calendar of mine in the future, I'm happy to entertain that. Or if you want to speak with her today about a plea in position number 43, I'm happy to give you that opportunity.
Thank you, Your Honor. I'll speak with her about that.
Okay. All right. Ms. Smith Wilcox, I know that we've been talking about you and I haven't addressed you. Good morning, ma'am. I'm certain that you've heard what's going on. I'm going to give Ms. Atai the opportunity to speak with you again regarding these charges, and we will come back with you. Okay.
Thank you.
Welcome.
Next is position 41, Ms. Satterwhite.
Okay. Does Ms. Satterwhite have an attorney, a conflict attorney assigned? Good morning, Ms. Strong. Have we assigned a conflict attorney for Ms. Satterwhite?
I see that we have, good morning, Judge. This is Ms. Lewis. I see that Ms. McLeod is assigned to her.
Okay.
I checked to see if Ms. McLeod is available. She may be in another court at this time, but I'll check her ETA.
Your
Thank
Honor,
you.
I know that she's currently, my understanding is that she had some court matters in Orca today for their calendar call.
Yes.
Okay. Thank you. Good morning, Ms. Satterwhite. Apparently your attorney has a conflict this morning. We will see if she can join us at a later time. If not, we'll see if we can place you on Thursday's SAP calendar. So I'll give Ms. McLeod the opportunity to join us this morning. Do we have, yes, Officer Milton?
That might be her calling me. Give me 1 minute, please.
Yes.
Your Honor, can we reset it for Thursday? Because I have a 9:30 calendar. I have to attend.
Okay. Let's see, we'll reset Ms. Satterwhite, position number 41 for Thursday, which is 7/11. I'll see you back on Thursday, Satterwhite.
Thank you, Your Honor.
Yes, sir.
Okay, who do we have next?
We can go to position number 6 and 7, Jaden Beebe. 5, 6, and 7, Your Honor. 5, 6, and 7.
Your Honor,
Okay.
can I have just one moment? I know that this is a not guilty waiver of arraignment, but if I could just have a moment.
Okay, let me know when you're ready, Ms. Vaughn. While Ms. Falk is until she gets back with us. Good morning, Ms. Vigiletti and Mr. Bede. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
He's talking to you. Is there by video?
Yeah.
Yes, thank you, sir. And you're gonna file a waiver, Ms. Vigiletti?
Yes, Your Honor. And I have a bond request as well, and I did just want to bring to Your Honor's
Okay,
attention that-
hold on, let Ms. Falk rejoin us.
Yes, I just logistically, I know Ms. Falk knows this because we talked about it yesterday. I just wanted to bring to your attention that Mr. Beatty had a felony case that was reduced to a misdemeanor recently and was accused as a misdemeanor yesterday, so it's not on the calendar, but will be a part of the discussion.
Okay, thank you. Can you give me that case number, Ms. Vigiletti, and the charge?
Yes, so the charge is simple battery against police, and I am pulling up the misdemeanor case number right now. Looks like the case number is 24 CR 004470A.
Thank you.
My apologies, Your Honor. I'm ready to proceed.
Okay. Have we gotten someone on from pretrial as of yet? Doesn't appear so. Do you have,
They're
Yes,
here.
Your Honor. I'm
yeah,
here.
Ms. Tyson,
Mhm.
good morning.
Good morning.
Do you have the history of Mr. Beatty for me, please?
Yes. We have 6 arrest cycles beginning in 2017. He has 1 FTA from 2020 out of Fulton County. And his last arrest was July 26th of 2021. That was by MARTA Police Department. It was for 2 counts of criminal damage to property in the first degree. There's no disposition listed on GCIC for that case. In Odyssey, let me check. I'm not sure if it's still open or not. Give me 1 second.
You have 6 cycles? I'm showing 8.
Yes, I'm showing 6 cycles.
Do you have the arrest from June 22nd, 2024 and the arrest from June 25th, 2024 by any chance?
No, I don't. It's not
Okay.
on here.
Okay.
It wasn't.
So then I think we updated ours yesterday. Well, no,
Okay.
about 5 days ago.
That might make sense because this
Okay.
one was run, I think, the beginning of last week. So yeah, it didn't show. 1 second, I'm checking on that criminal damage to property case.
Pretrial, I believe if that incident date was July 14th, 2021, it was pled down as a criminal trespass under 22 SC 180379, if that
Yes,
helps.
it was. Yep, it does. I did just pulled up. Yep. So it resulted in a misdemeanor conviction for criminal trespass. Yes, that's correct. Nothing to add, Your Honor.
Thank you. And the other 2, Ms. Falk?
Yes, Your Honor. So just wanted to mention, he also did have 2 criminal damage to properties in the first degree that were pled down to criminal trespass under 21 SC 179613. So he actually had a 2021 case that was closed out and a 2022 case that was closed out. He also has a 2020 SC 174340, possession of a pistol by a person under 18 years of age. He pled guilty to that on July 7th of 2022. He furthermore has an open, the simple battery family violence case, an open concealed carrying concealed weapon, giving false information case, an open terroristic threats and acts case, and an open simple battery against a detention officer, which was transferred down to us from the felony division. It was originally charged as a felony obstruction and transferred down, and we did accuse that yesterday. And so those are he currently has 4 open cases, as well as 3 cases that started in felony court but were pled down to misdemeanors, all since 2020.
Okay, and can you give me the bond on positions 5, 6, 7, and I guess if he needs a bond on the one that was pled down?
Right. So the only 2 cases he hasn't made bond on at this point is the terroristic threats ending in 4077A that he currently has a $1,500 surety bond on, and the case number ending in 4470A, where he has the simple battery against a police officer, where he has a $2,500 surety bond. It looks like the surety bond on the terroristic threats and acts was set by Your Honor on June 24th of 2024. And that is one of the bonds he's currently being held on. As far as the other bond, the simple battery, if I may just have a moment to see who set that bond. It looks like that bond was set prior to the case being transferred down to the state court, and that was set on, just looking very briefly at the documents, looks like that was set on June 26th, 2024. And unfortunately, I am not authorized to view that particular document, but it looks like it was set originally as a $5,000 surety bond. And then when the felony obstruction was dismissed, the $2,500 surety bond remained. That was set by Judge Elizabeth George on June 26th of 2024. So those are the only 2 bonds that he's being held on currently.
And I take it that the state wants them to remain the same.
Yes, Your Honor, we do. Given the defendant's history, he has actually, as we stated, had multiple arrests within the last 4 years, including arrests for gun possession. He was convicted of carrying a weapon under the age of 18. And then he had this terroristic threats charge where Your Honor gave him a $1,500 surety bond. That case was essentially, the facts of that case were on June 22nd of 2024. He threatened to commit a crime of violence to Shania Beatty, or Bibi, actually, by stating he would get someone to kill her. She is his mother. And so that threat was made on that date. And then the incident with the officer was while he was in the jail, he actually spit on detention officer. Let me get her name. He then spit on the detention officer inside of the jail while he was being held there. And that was the reason for his charge in felony court that was then subsequently pled down or sent down as a misdemeanor. And that was detention officer Lowe. We would like to sound for Mr. Bibi's mother to see if she is going to be present here in court today.
If Ms. Shanae Beatty is present and wishes to address the court, now is your opportunity to do so.
And Your
Yes,
Honor,
Ms.
I will state from talking to Ms. Bibi, she does agree with the plea offer. We did speak with her. She said she would try to be on the Zoom, but she is in agreement with the state's offer.
Thank you. Ms. Vigiletti?
Thank you, Your Honor. So Mr. Beatty, the problem, as Ms. Atai said earlier, when we have 4 different cases that happened at 4 different times, you know, one plea offer that resolves all of them can be coercive and coerce people into pleading to things they didn't do. And, you know, so, you know, Mr. Beatty, we need to address these cases individually on the merits. So that's why we're asking for a bond reduction this morning. He's been here for several years here in Atlanta. He does have a supportive grandmother who's here. Her name is Mary Boykin. She is on the line. Mr. Beatty spent some time in foster care, and as he aged out of foster care, he got a Section 8 voucher from the Atlanta Housing Authority that will expire next month if he doesn't make use of it. So, you know, he's on the time is sort of the essence here. He can make use of a really great supportive tool, and that's going to expire if he's sitting here in jail. Grandma is willing to assist in making sure he comes to court. I have her address and her phone number to use as his permanent mailing address for court mail until he is able to find a location for his Section 8 voucher. But our biggest reason, Your Honor, for asking for you to reconsider his bond this morning is that he is a participant in Urban League of Atlanta, which is a nonprofit that coaches and otherwise assists Black Atlantans to succeed. He's been working with Mr. Darius Baker. He's the senior manager of the Urban Youth Reentry Program. I talked to him at length yesterday, and Mr. Baker actually made a call and was able to get him a placement into Covenant House for tomorrow, as long as he's able to check in by 3 p.m. And, you know, in speaking with Mr. Baker, he explained that Mr. Beatty was very active in Urban League of Atlanta for a while and fell off, and he would love to have him back and help him find this long-term housing, because as you know, Covenant House is a short-term program, and he's also willing to help him with employment and education. You know, he really wants him to re-engage in the program. I do have Mr. Baker's phone number here if anybody would like to, you know, speak to him directly for verification. Our social work team is willing to pick Mr. Beatty up from the jail to transport him directly to Covenant House to make sure that we are, you know, getting him where he says he's going to go. You know, of course, Covenant House has certain requirements he'll have to abide by: no drugs, no alcohol, no weapons, no smoking, things like that. It's also my understanding that there's an MH factor in the case he picked up in the jail, and that he's not getting some medication he needs here in the jail. And Ms. Boykin has confirmed that his prescription is ready at Publix. And so, you know, it could be significantly beneficial to his MH status as well if he has a chance to be in a supportive environment, supported by Urban League, supported by Covenant House, supported by Ms. Boykin, and getting his proper MH treatment, Your Honor. So I am asking if the court to consider a signature bond on the 2 cases that are holding him, or if not, a significant reduction, so that, you know, his grandma is very supportive, but on a fixed income, and it would be her money that would be bonding him out.
Okay, and what's his grandmother's name?
Mary Boykin, she is here. I don't see her video on, but I do see her name, Your Honor.
Ms. Boykin, if you would like to address the court, now is your opportunity to do so.
Can you hear me?
Yes, ma'am. Are you able to activate your camera for me?
Let's see. Let's see. Start your video. Let's see. Oh, shoot. While using the app on at this time. Okay, start. Oh, man. Can you see me?
Yes, ma'am. Good morning, Ms. Boykin. Can you raise your
doing?
right hand? I'm doing fine, ma'am. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, you can place your hand down. What would you like to tell me about your grandson?
Well, what the public defender said is true. He does have Mr. Baker, and Mr. Baker did agree to, you know, help him to get on his feet and stuff like that. He's been a product of foster care. I think when he got in 14, he's been to different kind of homes. He's been to therapy centers and stuff like that. He got hit by a car about 2 years ago, 3 years ago. So he has brain damage. He goes in and out with his brain damage. And he does need treatment to help him with this brain damage where he needs to go to the neurology. But he does go to the therapy. He goes to Dr. V. I call him Dr. V. He's been going to him ever since he was about 10 years old, because he does have mental illness. And he does strikes off and on. He could not stay with me because I'm an elder. And with this brain injury he had, he came back a whole different person. He said he do not recognize who he is. You know, he want to get back into his own brain. So he said he's operating on somebody else's brain, but I could not have him in my home. That's why he's not in there. But he does have a place to go if he is released. He just need help. That's all I could say. He just need help.
And Your Honor, if I may, thank you, Ms. Boykin, because that reminded me, despite his brain injury, he has recently gotten his GED. And he's done his FAFSA and has already enrolled in Atlanta Tech. He hasn't started classes yet, but like Ms. Boykin said, Mr. Beatty is a person who wants to get back on the right track.
He just need help. And he got to want to help. And maybe this is an open wake-up call, because he have all the opportunity to him. He's not like a lot. He's just who he is, and he just want to get back to who he used to be. But that probably never going to happen with him.
Well, thank you, Ms. Boykin. I appreciate you being here today. Ms. Vigilante, tell me again where he's set to go when he's released.
Covenant House, and I'd be happy to put in a release order that, he should only be released to our social workers, taking him directly to Covenant House.
Okay. And as you were speaking, I was moving around. I was trying to check my notes from that SEA calendar to see if I had requested that the mother or the grandmother be here, which I quite often do at an SEA calendar, so that I can revisit the bonds that are set. I wasn't able to find my notes on it this morning, but I believe that is probably what I did, asking the SEA attorneys to see if they could have a family member present, because I didn't just want to release him on his own. But if you tell me that he will be going to Covenant House, I will. And before I say anything further, Ms. Strong, did you have something for me?
I have the order that basically just says that it didn't say that his family member needed to be on. It was just a no further contact with his mother and a social worker visit.
Okay. All right. Thank you, Ms. Strong. I appreciate it.
And Your Honor, if I can just check with Ms. Beebe, I believe she was on at SEA. She is here on the Zoom. She just did not wish to speak, but I can text her right now and just ask and confirm that.
She was on that day, because I did the C calendar that day with you, Judge. Miss Beatty was on. She did speak that day.
And she is the victim in this case. So she was here, she was present, she did speak. And my understanding is that in that bond order, you did also ask for a social worker visit. I would also just like to add, it is absolutely the PD's purview. If they wish to plead non-negotiated on any one case, they may do so. So the fact that they're alleging that this is inherently coercive, they absolutely have the right to proceed on a non-negotiated plea. They're choosing not to. And so I want to be real clear that this is not the state's fault for making a global recommendation. If the defense wishes to break that up and plead non-negotiated to any one charge, that is absolutely the defendant's right.
And I'm not going to make Ms. Shana speak if she doesn't wish to speak.
Good morning, Your Honor.
Yes, good morning, ma'am. Do you wish to speak or not? Like I said, I know that you said no in the chat, but if you want to address me this morning, I'm happy to hear from you.
Okay, sure. I would like to say.
Okay, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Yes, ma'am. What would you like to tell the court?
I absolutely agree with all the recommendations as far as the Covenant House and the supportive services, because he does need help. And I would just like to see him get the help that he needs. Like it was stated previously, he does have a voucher with Atlanta Housing Authority, and I hope that these charges don't prevent him from participating in the program, because it is a great opportunity. But as previously stated, he does have to want the help, so that's going to be totally, up to him. But he does, I know Mr. Baker has been very supportive, of him in the past. And I wholeheartedly believe that whatever he said he's going to do, he's going to do it, in regards to Jaden. And I just hope that Jaden receives the help that's, offered to him, if you are, so kind to give him a signature bond so he can get out and go to the Covenant House and start to recover his life.
Okay. And as far as contact with you, do you have a preference? Do you want him to have no further contact at the present time, or not?
Correct.
So no further contact at the present time?
No, sir.
Okay, all right. I just want to make sure. Well, I'll put that as part of the bond requirements also, and to stay away from your residence at the present time. So if nothing further, thank you for being here or speaking again, Ms. Beebe. The court appreciates your input. Ms. Vigiletti, with the conditions of the Covenant House, I will change the good bonds to signature bonds through pretrial level 2. Also, the stay away, the no further contact, that he'll go to the Covenant House, that he has to stay on any prescription medication that he's currently on, and okay, and if you'll get those, if you'll prepare those for the court, we'll get them signed. Jade, I'm going to give you the opportunity to get out and to get your life on the right path. But you have to know that if you violate these bond conditions, you're going to be right back where you are, and you won't get a second opportunity. Okay, from me. Okay.
There you go.
Ms.
Okay.
Vigiletti, how old is he?
His birthday is October of 2002, so I believe he's 21, turning
Okay.
20 in a couple months.
Okay, all right, thank you.
Did you have something else, Ms. Strong?
Which ones are the terroristic threat which one was the other one?
The other one is not on the calendar, Ms. Strong, and that is going to be 24 CR 00. Let's see.
4470A.
Yes, thank you, Your Honor. 4470A.
And that's simple battery against a police officer, I think.
Yes.
Okay.
Thank you.
Anything further, Ms. Vigiletti?
No, Judge, thank you.
All right. Good luck to you all.
Excuse me, Your Honor. This is Milton at ACDC.
Yes.
Ms. Atai needs to come back to address you for this young lady, and her mother is on the Zoom.
Okay, thank you. Yes, Ms. Atai, tell me is this Ms. Smith Wilcox?
Yes, Your Honor, for position 43.
43, and what are we gonna do this morning?
A non-negotiated plea, Your Honor.
Okay, just on position 43, is that right?
Just on position 43.
And what's non-negotiated about it?
Your Honor, she's fine with the 12 months probation, credit for time served, that she wouldn't be serving any more time. She does want contact with her mother, and her mother wants contact with her, so we'd be asking for no violent contact. The stay away provision is fine, and I would ask for an alternative rather than FVIP. She is going to be going to Mary Hall, where she'll be staying for at least 30 days to 3 months, so that she's not homeless and she can take advantage of the services that they offer. But the FVIP, I believe it's now at least $500. So she just wouldn't be able to afford the FVIP.
Sorry, ma'am. We want to give you a number.
Is Miss McGinty on the line? I see you there, Miss Tracy McGinty.
It's 4-0. 612.
Ms. McGinty, if you'd like to address the court, now is your opportunity to do so. Okay. Ms. Falk, would you tell me the facts on, it appears that either she's not with us or she doesn't want to address me, but Ms. Atai, if you've spoken with her, then I'm gonna.
I just called her. Sorry, Your Honor. I just called her to get on the call. I can try to call her again. Maybe she's.
Well, it looks like she's on the call, but she's not responding to me.
Right. And the reason the state would like her to respond is just because that is different than what she told the state, which is she didn't want contact. And so I just want to clarify with her. I'm not saying I don't believe PD Atai, just I would like her to clarify if it's the no further contact she asked for just a couple of weeks ago, or if she wants no further violent contact.
Okay, I understand, Ms. Falk. So, Ms. McGinty, I see you there. Can you unmute yourself for me, ma'am? And maybe put a little light in the room.
Can you see me?
Yes, ma'am, I can see you. Good morning, Ms. McGinty.
Good morning.
Can you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can place your hand down, Ms. McGinty. I don't know if you've been listening to the conversation, but
I've been listening.
okay, so we the court needs to know whether or not you'd like contact with Ms. Smith Wilcox, who I believe is your daughter. Is that right?
Yes, I would like to have contact with my daughter.
Okay. Anything else that you would like to tell me this morning regarding this?
I have her son, and I do miss my daughter, and I just want her to get some help.
Okay, and there's also a stay away from your residence. Do you still want her to stay away from your residence?
No, I have her son. She need to see her son.
Okay. Ms. Falk, do you have any questions that you'd like to ask Ms. McGinty?
Ms. McGinty, is this the first time that you have ever had an incident of violence with your daughter?
Yes.
Okay. And that's all actually for the state. Nothing further.
Okay. So the only thing that is non-negotiated at the present time would be the FVIP. Ms. Falk, would you have any objection to the court changing that to 12 weeks of anger management?
Yes, Your Honor. Under 1913-10, this is a family violence offense. And based on that, and based on the statute that governs it, which would be 42-8-35.6, the defendant shall do family violence intervention program, which is governed by the statute. That's the reason the state asked for family violence intervention program.
Your Honor, I would just ask, I mean, if there's a way for her to do the family violence intervention without the cost. She has no problem availing herself of any and all therapy courses. She wants to improve her life, but it's $500 at least.
Okay, what I can do,
and I will say under subsection D of that statute, the cost is on a sliding scale based upon the defendant's ability to pay.
okay. So, I'm gonna require her to do the family violence intervention, Ms. Atai, but I will waive the probation fees during the course of while she's on probation to help her out that way. And if it's on a sliding scale, then hopefully she'll be able to get herself employed once she is able to and get that course done. She'll have the entire 12 months to get it done without having to worry about the fees. Okay?
Okay, thank you, Your Honor.
All right, anything further before I take the plea?
Just the state wanted to put our recommendation on the record, Your Honor. I understand this is non-negotiated. 12 months probation served 70 days, credit for time served 35 days from June 4th, 2024, balance probated. The state understands that Ms. McGinty now wants contact, so we are willing to modify our no further contact to no further violent contact with Tracy Everett McGinty and eliminate the stay away request. We are also requesting family violence intervention program for count 2, the criminal trespass. It would be 12 months concurrent with count 1. The state would ask the defense to stipulate to venue factual basis and identification for the purposes of this plea.
We do so stipulate.
Anything further, Mr. Ty?
Nothing further, Your Honor. I just want to clarify, though, that the 12 months of probation, the fees have been waived for the entire 12 months.
The court is willing to do that.
Thank you, Your Honor.
Okay. So, Officer Milton, can you unmute for me, please? Thank you. Ms. Smith Wilcox, can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can place your hand down. Thank you, ma'am. It's my understanding that in case 24 CR 003511D, you wish to plead guilty to simple battery, family violence, and criminal trespass. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with her representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I will accept your plea, Ms. Smith Wilcox, and I'll also accept the state's recommendation. 12 months to serve 70 days, credit for time served 35 days, balance probated, no further violent contact with Tracy McGinty. Family violence intervention program. For the criminal trespass, 12 months probation concurrent with count 1. The court will waive the probation fees while you're on probation. And I think that covers it. Good luck to you, Ms. Smith Wilcox.
Thank you, Your Honor.
You're welcome. Ms. McGinty, thank you for being here this morning. The court appreciates it.
Thank you, Your Honor.
All right, we'll see you this afternoon, Officer Milton.
Yes, sir.
Okay, have a
Thank
good
you.
morning.
You too.
Who do we have next?
We can go to position number 3, Mr. Nicholas Bailey.
Okay. A negotiated plea, is that correct, Ms. Vigilante?
Yes, Your Honor.
Good morning, Mr. Bailey. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you, Mr. Bailey. Ms. Falk?
Yes, Your Honor, the state's recommendation is 12 months probation served 50 days, credit for time served 25 days. That's going to be from January 10th, 2023 to January 12th, 2023 and June 18th, 2024 until today. Balance probated, no further contact with Juan Alvarado, stay away from 235 Peachtree Street Southwest, and 8 weeks of anger management. We would like to sound for Juan Alvarado at this time and do ask the defense to stipulate to venue factual basis and identification for the purposes of this plea.
Mr. Alvarado is on the line and wishes to address the court. Now is your opportunity to do so. Ms. Vigilante?
We do stipulate, Your Honor, and I did just want to request this morning, Mr. Bailey is on probation in 2 other counties, which, as you know, can be quite expensive, and he does need to go to those other counties to handle some probation matters, very likely related to this charge. So if Your Honor would be willing to consider waiving some probation fees and allowing his probation to go to non-reporting status upon completion of the 8 weeks of anger management. I think it would be extremely helpful for Mr. Bailey.
I'll have it go to a non-reporting status so that he doesn't have to pay the fees. He should be able to get through the anger management relatively quickly. And that will give him incentive to do so. So I won't waive any probation fees, but I will make it go non-reporting, okay?
Okay, thank you, Your Honor.
You're welcome. If nothing further, Mr. Bailey, it's my understanding that in case 23 CR 0000143A, you wish to plead guilty to battery, is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to, to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiated, Mr. Bailey. When you complete the terms of the probation, it'll go to a non-reporting status. So the sooner you get it done, the sooner you won't be on reporting probation, and the sooner you don't have to pay the fees, okay?
Yes, sir.
All right, good luck to you, sir.
Thank you, Your Honor.
You're welcome. Good morning, Mr. Murphy. What cases are you here on this morning?
Judge, I've got Chris Thompson.
Position 44, Judge.
Okay. Do we have Mr. Thompson?
Judge, I was recently appointed.
Oh. Yes. Can you hear me, Mr. Murphy?
I can.
Okay. Do you need to speak with him, or what's your request this morning of Mr. Thompson?
Judge, I hadn't received any discovery, gotten the state's offer, which we're declining. So at this point, I was looking to motion to reinstate the existing bond. Our assertion is Mr. Thompson is missed court due to not receiving notice and the problem with the mail. But he has a discernible address. And
I'm sorry, do we have Mr. Thompson in courtroom 2?
Yes, we do, Your Honor.
Okay, can you bring him up for me, please? Yes, good morning, Mr. Thompson. Let's see, Ms. Falk,
Yes, Your Honor.
did he miss a court date?
Couple, Your Honor. So he on this, we're talking about Demetrius Thompson, correct?
Yes, position number 44.
Okay. So Mr. Thompson had a, let's see, failure to appear April 26, 2023 before Judge Eric Richardson. The warrant was issued April 28th, 2023. The defendant then made a new bond on July 22nd, 2023. It looks like there was then a bond surrender on June 19th of 2024. So that's actually what has brought him before us today. That looks like it was on a failure to appear. $6,000 surety bond was set by the judge. Let me look at the FTA on that. He also has a failure to appear in felony court. Let's see. So the bond surrender was issued on a failure to appear, the date of the previous bond being cited back to July 22nd of 2023. The failure to appear was issued by Judge Richardson on actually November 8th, 2023, before I take it back, before Judge Scott McAfee. So the reason his bond was surrendered in this case looks like because of his failure to appear in his felony case, which is 23 SC 189542. Where he failed to appear for felony court. And then it looks like that triggered not only FTA and felony, but them to surrender his bond in our case. He also is being held on a number of other charges. He's got a hold for aggravated assault, possession of a firearm during commission of a felony, criminal damage to property in the second degree, use of a firearm by a convicted felon, and receipt and possession of a firearm. Those are all of the cases that he failed to appear on in felony court.
Oh, no.
Okay, thank you, Ms. Falk. Mr.
you.
Murphy, it's what I normally do is send it back to the division judge. I think that I will do the same in this case and let Judge Richardson decide what he'd like to do at that point, okay?
Okay, duly noted, Judge, and I'll advise
Okay.
my client and his girlfriend. I appreciate it, Judge, and I'll file something with Judge Richardson. Thank you,
Okay,
Judge.
Very
Richard.
good. I think, is that your only case with us today?
It is indeed, Judge. I'm here with Orca.
Okay, I'll see you next
you.
time. Thank you, Mr. Murphy.
Thank you,
And
Judge.
Mr. Thompson, your case will be returned to the division judge. You'll get notification of your next hearing date, sir. Who do we have next?
We can go to position number 9, Mr. Bloodworth.
Ms. Vigiletti with us?
Yes, Your Honor.
The note says you need additional discussions.
Yes, Your Honor, we've spoken again, and Mr. Bloodworth would like to enter a negotiated plea this morning.
Okay, very good. Good morning, Mr. Bloodworth. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you, sir. Ms. Falk?
Yes, Your Honor. State's recommendation on this case is 12 months served, 30 days, credit for time served 15 days from June 25th, 2024 until today. Balance probated. No further contact with Annie Watson, DeMarcus Willis, Jacqueline Escovedo, Catherine Hood, and Matthew Johnson. Stay away from Tacos and Tequila's Mexican Grill located at 650 Ponce de Leon Avenue Northeast. Anti-theft course is also being requested. The state would like to sound for the following victims: Annie Watson, DeMarcus Willis, Jacqueline Escovedo, Catherine Hood, and Matthew Johnson. And the state would also ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea.
If any of those people are on the line and wish to address the court, now is your opportunity to do so. Yes, Ms. Vigiletti.
We do so stipulate, Your Honor, and I did want to request this morning, Mr. Bloodworth is currently homeless and not working, and he does also have a felony probation set of requirements. So if Your Honor would be willing to consider waiving probation fees and perhaps making probation non-reporting upon completion of the anti-theft class, I think that would be very helpful. We have discussed shelter options, but as you know, shelters are temporary and you know, it's difficult to find permanent housing from temporary shelter.
Okay. Mr. Bloodworth, it's my understanding that in case 24 CR 004149F, you wish to plead guilty to theft of lost or mislaid property. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with her representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated. You should be able to get through the theft class hopefully pretty quickly, Mr. Bloodworth, but I will waive 1 month of probation fees to help you get through that class. I will also make the probation go non-reporting once you complete the class. So the sooner you get it done, the sooner you won't be on reporting probation. Good luck to you, Mr. Bloodworth.
Thank you.
Thank you, Your Honor.
You're welcome. Good morning, Mr. Fortis. What case are you here for this morning?
Good morning, Judge. I'm here for Mr. Joshua Jimenez. I'm here for Mr. Spiesman this morning. Good to
Okay.
see you, Judge.
You also, Mr. Fortis. Let's see, what are we going to do with Mr. Jimenez this morning?
Judge, what I would like to do is the court to be heard. I'd like for the court to be heard on possibly reinstating the bond or giving a new bond on the case so he can have an opportunity to fight the case. There have been negotiations that have been ongoing between Ms. Falk and Mr. Spiesman, but absent a potential plea today, we would like the court to consider first reinstating the bond. And I think I have a compelling argument for the court.
Okay. Do we have Mr. Jimenez and court here and stuff to bring it forward?
No, Your Honor. He should be produced on jail court's iPhone.
Okay. So, Mr. Fortis, he is not with us this morning. We normally, what happens is that once we get through everyone that's in the courtroom, there'll be a jail court's iPhone that they will take around to interview other people. So, I wish I could move your case along this morning, but unfortunately, I'm unable to.
Well, Judge, with respect to being heard with respect to reinstating the bond, can I waive his presence with respect to that particular issue and be heard on that?
I think that you'd have to speak to your client first to have a waiver of his presence. So, and Ms. Falk, did he miss a court date?
Your Honor, actually, I'm looking at an order that looks like it was signed by Judge Edie today, reinstating the original bond. So I don't think Mr. Fortis got the memo from Mr. Spiesman, but that's what I'm showing in the clerk's record as of today.
Okay. Well, and what was the bond amount, if I may ask, Ms. Falk?
I don't know what the original bond was. I just know what the bond was set upon his forfeiture, but I'm not sure what the original bond was, but I would assume Mr. Spiesman would know.
Okay, well then I think we're all good here, Judge. And if there's an issue, I'll log back on.
All right, very good. Have a good rest of your day, Mr. Ford. It's good to see you as always.
You as well, Judge Morrow. Take care.
Who do we have next in courtroom 2?
We can go to position number 10, Mr. Brownlee.
That's a negotiated plea, Your Honor.
Good morning, Mr. McClain. Thank
Good
you. Good morning, Mr. Brownlee. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. Yes, Ms. Falk.
Yes, Your Honor. The state's recommendation on this case is 12 months served 30 days, credit for time served 15 days from June 25th of 2024 to today. No further contact with James Jones. Stay away from 1940 Fisher Road Southeast. 12 weeks anger management, 40 hours community service, no firearms or weapons. State would ask the defense to stipulate to venue factual basis and identification for the purposes of the plea. We also would like to sound for Mr. James Jones.
Mr. Jones is on the line and wishes to address the court. Now is your opportunity to do so. Mr. McClain?
Your Honor, for the purposes of the plea, we do stipulate, Your Honor, he would like to ask for whatever break the court could give him on fees. Fees for the first several months of probation, as he did express to me in general terms that finances are tight.
Okay. Mr. Brown, it's my understanding that in case 24 CR 004150G, you wish to plead guilty to battery. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated. I can't waive any fees, Mr. McClain, but I can have it go to a non-reporting status once he completes the term. So as soon as he gets it done, the sooner he won't be on reporting probation and we won't have to pay those fees.
That would be
Good
super,
luck.
Your Honor. Thank you. No, 132, that's just me.
Position 16 and 17, Mr. Delmore, and he's a conflict.
Okay, have we assigned a conflict attorney to Mr. Delmar?
No, Judge, not at this time. I'm not aware of it being a conflict, so we'll have to either reset them or I to see if Ms. McLeod could step in, but right now, he does not have one assigned to him, was not aware of it.
Okay, well, it appears that Ms. McLeod, Mr. Murphy, are otherwise taken up this morning.
Take that back, Judge. I do see a conflict attorney. I'm sorry. We talked about Mr. Joshua Delmar.
Yes,
Tia
positions.
Watson was assigned to him at one point. She's assigned to him.
Ms. Watson Cafe?
Yeah, Ms. Watson Cafe. Mhm.
Okay.
I don't know if she's aware of the court setting. I will try to reach out to her.
Okay, if you can reach out to her and get back, if we can handle him today, I'd prefer to do that. If she is otherwise occupied this morning, we'll have to reset him till Thursday.
Okay, I'll reach out to
Okay.
her. Thank
All
you.
right, thank you. Just let me know, if and when she responds. So we'll come back to Mr. Delmar. We'll see if we can get in touch with Ms. Watson Cafe this morning. Anyone else? Yes.
Your Honor, to interject, if I might, I have one of my defendants, one of my client's sisters is available at 10:35 this morning, and that's Mr. Ricky Ingram. So if 10:35 looks like a convenient time to do that case, she's got a half hour free from her work meetings.
Okay, and does the non-negotiated part have something to do with her wanting contact? Is that why you want her here?
No, she's just going to observe, and she may have something to say about it's a non-negotiated plea as the extra jail time, so she might have something to say about her brother.
Okay, well, work that out with courtroom 2.
And Your
Okay.
Honor, I do need to ask the court for a reset on our person who's temporarily housed in the Cobb County Jail. His name is Norris Henry. And he's number 20, 21, 22, 23?
23.
23. I need to ask for a reset on that. Your Honor, he has a open case in a county in which I have to read that police report to understand exactly how to best ask for a bond reduction. Tuesday would be good, 7 days from now, but I'm flexible on the reset date.
So 7/16, I believe, is
Yes.
a week from today.
Yes, Your Honor, that would be.
Okay, so position 23, Mr. Norris Henry will be reset until next Tuesday, 7/16.
Thank you.
You're welcome.
And
Anyone else in courtroom 2 that we can take, or medical?
there is, but I have a question on 2 of the defendants' names.
Okay,
Announcement, it says they need a conflict attorney. Mr. Grace, position number 18, and Mr. Davis, position number 15. I'm not sure if they have anybody yet. You guys.
Okay. Have we assigned anyone to position 15 and 18?
Okay, this is Katrina again, Judge. Let me give you an update. Ms. Watson has a leave of absence in from July the 5th through July the 22nd. So she has a leave that she filed.
Okay, and that's on position 16 and
That was on Lamar. Yeah, 16,
Smith.
17.
Okay, and her leave, when's it go through?
It's through July the 22nd.
July 22nd.
Mm-hmm.
Okay,
So that would make the next available date the 23rd. It looks like from the SAP calendar.
right, so that's
And that's for 16 and 17?
yes.
I mean, if Your Honor consents to that date.
What?
I mean, that's fine with me. I just hate for him to sit in jail for the next 2 weeks simply because she's got a leave file, but this is her client and without her here, I don't think that we can move forward. So we'll reset it for the 23rd.
And what about position 15 and 18?
Okay, so you're with me, Ms. Lewis? Can we talk about position 15? Roderick Davis, is there a conflict set for that for Mr. Davis?
15, Mr. Davis. Nope. There's not one
Okay.
set for him. I was not aware of it. I don't know, are these things are coming up at the time when they were on the SEA counter but they were not noted? You know, normally on the SEA counter, we'll know if there were a conflict, but now it's like all of a sudden these are conflicts coming up and, you know, we don't get prior notice until we get these announcements.
I'm sorry, Ms. Lewis, I sent them to Mr. Jordan a couple of days
Yeah,
ago.
if you could CC all of us on it so we're
Sure,
aware, because
I'll
Mr. Jordan
start
sometimes
doing
be really busy.
Yeah, I know, and we catch so many conflicts at SAP because we're diving into the facts, you know, so much more than SEA, but I'll start sending it to all the litigation managers because
Yeah, then we need to know a timely matter because at the day of the counter like this, it's kind of confusing and kind of hard to get some conflicts attorneys when we're not aware of it at that time.
yeah,
So,
there's a lot today.
yes, especially if they've been reset for 2 weeks, we should be able to know prior to that.
Yeah, absolutely.
Okay.
So Judge, right
So-
now, we do not have a conflict attorney for Mr.
Okay,
Davis.
so let's assign a conflict attorney. I'll reset this for a week, given the recommendation is 180 days. So we'll reset position 15, Mr. Davis for 7/16. And on position 18, is that the same? We're in the
No.
same posture with that, Ms. Lewis? Gary Grace,
I'm checking that now too. Yep, same scenario.
okay.
Yeah, you know.
Reset him also to 7/16. Okay, did you get that too?
Yeah, I got that. And for Miss Watson case, her client's in jail on a FTA, so that's the only thing. I don't know if she's probably aware of that or not, but like I said, I mean, I can shoot her an email, but like I said, she's on leave.
Okay, thank you, Ms. Lewis. Who else do we have that we can take?
We can go to position numbers 12 and 13, Corey Comer, 12, 13, and 14, Mr. Comer.
Okay. Mr. McLean, these are non-negotiated, please.
Yes, Your Honor. The one in the middle, number 13, is an FTA. Number 12 is a simple battery. And number 14, the state was offering a time served as the jail portion, but their offer is, of course, a global recommendation, which we recognize their right to make a global recommendation. So in a sense, even though he would like the time served on the jail portion on that one, in a sense, it's all unnegotiated, it's all open.
So the additional jail time is what's non-negotiated.
Correct, and that's on only, right.
All right, so let me, Mr. Comer, good morning. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir. How you doing this morning?
I'm doing well. Thank you for asking, Mr. Comer. Can you raise your right hand for me? Do you swear or affirm the testimony that you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Sure.
Okay, you can place your hand down. Ms. Tyson, may I get the history, please?
Yes, defendant has 14 arrest cycles beginning in 1987. He has 4 felony convictions outside the 10-year period. Sorry. He has one out of Cobb County for possession of tools for commission of a crime, theft, larceny. That's from 88. He has another one for dangerous drugs from 1990. He has a third from Fulton County for 2 counts of armed robbery and theft by taking. That's from 1993. And the fourth is out of Fulton County for manufacture, sale, dispense, distribution of drugs, and possession of a firearm or knife during the commission of. That's from 2005. Then the last 10 years, he has a felony conviction out of Cobb County for manufacture, deliver, distribute, administer, sell, possess with intent to distribute controlled substances. That's from that's outside the 10-year period also. That's from March of 2012. He has one FTA from 2004, one violation of parole from 2014. His last arrest was in Atlanta, July 9th of 2021 for battery, family violence, first offense. No dispositions listed on GCIC for that case, Your Honor. Nothing to add.
Ms. Falk?
Yes, Your Honor. So there are these 2 separate cases. The defendant's currently on a failure to appear on a $20,000 surety bond and a $2,500 pretrial services bond on a simple battery case, which is the one that appeared on the calendar. As far as the July 11th case, that incident happened July 11th of 2021. Ms. Comer, who is Kimberly Comer stated that the defendant became upset because she told him that their mother wanted everyone out of the house. Their mother was very sick and wanted the house to be cleaned up. Miss Kimberly Comer is the sister of the defendant. They exchanged words. He then pushed Miss Comer down to the floor. She stated she felt as if he was trying to hurt her at the time of this incident. That was the July 11th, 2021 incident. The other incident that occurred was July 9th of 2021. In that case, the defendant grabbed his ex-wife by her neck with his bare hands during a dispute. The 19-year-old son stated that the defendant wrapped his hands around her neck and he pushed her up against a wall. The victim in this case, at that time, it was observed she had a bruise to the left side of her neck that was consistent with the injuries that were described by both the son and the mother in this case, who is, and let me just pull up her name very quickly. Her name is Shawanta Smith. We would like to sound for both Shawanta Smith and for Miss Kimberly Comer. I will state that the state's recommendation was largely based on the fact of his history, which, although it is distant, also includes armed robberies for which he spent, my understanding is an amount of time. Let me just double check the time he spent on that case, because normally that would receive a 10-year prison sentence. But let me just double check on that. And so the state did have concerns because there is a history of violence, obviously, with the armed robbery, as well as some drug charges, even though they were outside the 10-year period. But the state did have those concerns, as well as the fact that on one of the cases, it involved essentially him placing his hands around her throat, leaving bruises on her neck. Which the state was very concerned about how that situation came about and the fact that she had injury to her neck. It looks like the defendant spent 8 years in prison on the armed robbery case and theft by taking charges, and then spent another 10 years in confinement in 2005 on the manufacturing, sale, distribution, and possession of firearm by a convicted felon. And that time was actually, he did, it looks like 15 years because it was a 10-year confinement sentence and then 5 years. And then in the 5 years, it says consecutive to count 1. So a large part of why the defendant has not had new charges recently is because it looks like he's been spending quite a lot of time in the prison system. So that's all for the state. And we would like to sound for Miss Comer as well as Miss Shawanta Smith.
Mr. Comer,
Yes,
Corey
sir.
Comer or Shawante Smith or Kimberly Comer are on the line, and wish to address the court, now is your opportunity to do so. Ms. Falk, did you place your recommendation on the record?
Oh, my apologies, Your Honor. On position 12, state's recommendation is 12 months served, 26 days, credit for time served 13 days, balance probated. No further contact with Kimberly Comer. Stay away from 50 Mount Zion Road Southwest. Family Violence Intervention Program, which is part and parcel of position 14 and 40 hours of community service. On position 14, it's 12 months probation, 45 days, credit for time served 15 days. That's going to be from July 9th, 2021 to July 10th of 2021, and then June 27th of 2024 to today. No further violent contact with Shawanta Smith and CC Jr., who is the child, who is the son of Miss Smith and the defendant, and FBIP. Count 2, the cruelty to children in the 3rd degree, 12 months concurrent with count 1. So we are asking for additional time on the family violence battery based on the defendant's history.
Okay. Mr. McLean?
Some corrections, or minor corrections, Your Honor, in that he didn't spend 10 years in prison on that the VGCSA case. It was 5 and then 5 parole. Also, Your Honor, the that terrible sounding armed robbery from the early 90s, that was 1 count, not 2. Your Honor, the only difference we have in his pleading guilty, he is looking at 45, if you round that off to 46 divided by 2, and that becomes 23 minus 15. He's looking at 8 extra jail days had it been negotiated, and he would like to ask the court to consider that given that these cases were 2 days apart in 2021, the summer of 2021, he would like to ask the court to consider giving him 0 extra jail days at this time here in 2024, and he'll get on with his probation and do his FVIP in 40 hours. And the no further contact with, I believe it's Shawante Smith and CC Jr., and stay away completely from his sister. We went over in detail, we went over all the elements and any distinctions and nuances.
Okay. Given that this is a 2021 case, I won't require him to do any additional jail time, but I am going to add 40 hours of community service to position number 14. So will make him have 80 hours of community service total. As far as the family violence intervention program, of course, he'll just have to do one of those to satisfy both of the charges.
Understood. 80 hours.
Okay.
Of community service. We'd be on yeah, it's $25 per week. Thank you, Your Honor.
Okay, are we ready to proceed?
Yes, Your Honor.
Your Honor, my apologies. I don't know if I asked. The state would ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea.
For those purposes, we do.
Mr. Comer, it's my understanding that in case 24 CR 004187J, you wish to plead guilty to simple battery, and in case 21 CR 003328J, you wish to plead guilty to battery, family violence, and cruelty to children in the 3rd degree. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir, I do.
Has anyone forced or coerced you to plead guilty?
No, sir.
I will accept your plea, Mr. Comer. Let's see, for position 12, the simple battery, it'll be 12 months to serve 26 days, credit for time served, 13 days, balance probated, no further contact with Kimberly Comer, stay away from 50 Mount Zion Road address, Family Violence Intervention Program, and 40 hours of community service. For position 14, for the battery family violence, it will be 12 months to serve 30 days, credit for time served 15 days. No further violent contact with Shanta Smith and Corey Comer. Family Violence Intervention Program, 40 hours of community service. And for the cruelty to children, 12 months probation concurrent with the battery family violence. All right, good luck to you, Mr. Coleman.
Your Honor, he does have a disability check, so it's a very fixed income. If it would be possible during that first 5.5 months of the FVIP, if a portion of those months could have a break on the $49 a month probation fee of supervision, that would help him financially.
I appreciate that, Mr. McLean, but I'm not able to waive the probation fees on each and every case that comes before me. I take them on a case-by-case basis. And as far as Mr. Comer goes, I think that he should be able to pay those probation.
He will figure it out, Your Honor. Thank you.
All right, good luck to you, Mr. Comer.
Yes, sir. Thank you.
Position number 24, Ingram.
And this is Mr. Ingram and medical.
Yes.
Okay, and this is also not non-negotiated plea.
Yes, Your Honor.
What's not negotiated about it? What time?
The extra jail days, yes, Your Honor. The serve time.
Okay, good morning, Mr. Ingram. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Good morning, sir. How you doing?
I'm doing fine. Thank you for asking, Mr. Ingram. Do you agree to have your case heard by video this morning?
Yes.
All right, thank you, sir. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you, Mr. Ingram. Ms. Tyson, do you have Mr. Ingram's history for me, please?
Yes, we have 23 arrest cycles beginning in 1981. There's 3 felony convictions outside of the 10-year period. One for burglary, theft by taking, that's from 81. The second's for burglary from 87. The third is from entering auto from 1989. And the fourth is for theft by receiving stolen property. That's from 2004. Then the last 10 years, I apologize, I'm sorry. And there's a second case from 2004 for armed robbery, burglary, and possession of a firearm or knife during the commission of. There's also another case from 2007 for theft by receiving stolen property, possession of a firearm by a convicted felon, and carrying a concealed weapon. That's from 2007. The last 10 years, he has 4 violations of probation. He has an FTA from 2019. He has a misdemeanor conviction out of Fulton County for theft by shoplifting. That's from 2019. And he has another for theft by receiving stolen property, misdemeanor from 2016 out of Cobb County. Nothing to add, Your Honor.
Ms. Falk?
Your Honor, I do have some additional items to add. The defendant has a 17 SC 151901 burglary in the first degree. He was found guilty on that case in Fulton County, and it looks like given a sentence of 17 years with 20 years with 3 years to serve. So he is currently on open probation on that case. That sentence was January 4th of 2018. So that was within the last 10 years. He also has, according to my information, a 2012 conviction for theft by receiving false information given to law enforcement and driving without a license. That looks like he was convicted on December 3rd, 2012 and given 2 years to serve on that, on those series of cases, as well as a 12 SC 10787 case, theft by taking, auto obstruction of a law enforcement officer, driving without a license. That was also a non-negotiated plea. On that, he received 10 serve 1. So he actually, he will be he's off probation on that, but still on probation on the burglary case. In this case, in chief, Your Honor, the defendant on June 25th of 2024, officers met with Mr. Christian Herndon and Lakeisha Moore. They stated that they were asleep upstairs when they heard a commotion. They came downstairs and observed the defendant beating Miss Andrea Tabb. After they
Those are all lies. Those are all lies.
Hold on. Whoever that's speaking, we do not do that in this court. You don't interrupt anyone. You understand me? If that's Miss Kedra Denham, I will give everyone the opportunity to speak, but we don't interrupt. I'm sorry, Ms. Falk.
I'm
Yeah,
sorry
sure.
as well.
So they went downstairs, were able to successfully break up the physical altercation. Mr. Herndon then returned upstairs to contact law enforcement. Mr. Herndon and Ms. Moore granted officers entry into the unit. At that time, they observed the defendant positioned on top of the Miss Tabb. Miss Tabb had swelling on both sides of her face, a busted lip, and her clothes were on the floor covered in blood. The Miss Tabb stated upon exiting the restroom that her live-in partner, the defendant, threw a cup at her while asking where his phone was. She advised she did not have his phone, which evolved into the defendant striking her multiple times in her head and face, causing bruising to her eye, lip, and cheek, which also the officers were able to observe. And that, plus the testimony of Mr. Herndon and Ms. Moore as far as what they observed when they were confronted at 12:57 with the sounds of the domestic dispute that they then had to break up. The defendant was determined to be the primary aggressor and was placed under arrest. So that is how that case came to be. We have, let me just check my, check something really quickly. We did have contact with Miss Tabb about 2 weeks ago. She said that they were in a relationship 10 years ago, that her niece is their caretaker. She had them move upstairs in her home. She stated the defendant has been trying to get back together with her, and she was woken up from her sleep to him groping her. She stated that they were in a relationship. When they were in a relationship, the defendant was abusive towards her. She did confirm the events in the report, stated she is afraid of the defendant. She sustained a black eye and a busted lip. Again, that is what the officers were able to observe as well. She stated the defendant gets aggressive when he is under the influence. For that reason, the state's recommendation was 12 months, 180 days, credit for time served 15 days, balance probated, stay away from 3110 Godby Road in College Park. We are agreeable to a one-time escort for her belongings. We also are asking for no further contact with Andrea Tabb, ADET, as well as FBIP, 40 hours of community service, and no firearms. And Your Honor, our recommendation was based largely in his history, which includes the fact that he is currently on open probation for a burglary in the first degree when this incident did occur. And so that would have been a violation of his current probation. That's all for the state. And we would like to sound from Ms. Andrea Tabb, Your Honor.
If Ms. Tabb is on the line and wishes to address the court, now is your opportunity to do so. Mr. McLean?
Your Honor, Mr. Ingram is asking the court to consider, instead of the 75 extra jail days, something smaller. He realizes that this is a very serious matter. He's going to take the FBIP. He's going to get the alcohol and drug evaluation and do the treatment if it's recommended. He's going to do that 40 hours of community service. But instead of 75 extra days, if the court could consider, well, we would always think of asking, of course, for 0 extra days in the appropriate circumstances. But he realizes that with what's been said and what's on his record, that he should ask the court for consideration of even 1 month extra instead of 2.5 months extra. he feels that he will be able to get on with his affairs. Your Honor, he has a fixed income. He has rent that he's afraid that if it's 2.5 months, his belongings are going to be on the sidewalk. It's not so much the furniture, but everything he owns will go to the wind. And that'll give him a really hard time starting back up.
Can I say something yet?
I think we've covered it.
Okay, do you want Ms. Denham to speak or not, Mr. McLean?
I haven't spoken with Miss Denham. She is not the sister whom I called. So I don't know what Miss Denham, out of an abundance of caution, I usually don't like to, what's the old adage
I'm
about?
his
Doesn't
caregiver.
ask a question unless they know the answer. So I would rather go with his sister testifying if she wants to say something good about his character.
Well, what's his sister's name?
Let's see, I don't have the sister's name, but is she on? She was the one with the 10:30 ending of her work meetings.
I'm his caregiver, and she called me and told me to do it. He stays with me, and I got him through the state.
All right, Ms. Denham, if you want to address the court, I'm happy to hear from you. Raise your right hand for me. The other hand, please. Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, and who are you to Mr. Ingram?
I'm his caregiver, and I was also Andrea Tabb's caregiver as well.
Okay, do you know anything about this incident?
Yes, sir, I do. I know a lot about it. Actually, we was all staying there. The lady, Andrea Tabb, she's on drugs very heavy, and I had to
Your
go
Honor,
through the
I'm going to
states.
object to this unless this witness, who is not anywhere on the warrant or in the information or the police report, is
Excuse me,
present
ma'am.
on-
I'm the one who's been calling the police.
Hold on, hold
Your
on,
Honor,
hold on, Ms. Denham. Let me hear the objection first. Go ahead, Ms. Fall.
Yes, Your Honor, thank you. Unless this witness, who is nowhere in the police report or in the witness or on the warrant, was present on Tuesday, June 25th, 2024 at 12:52 a.m. when this incident happened and police were called, she would not be, this information would be hearsay.
Now, let's unmute Ms. Denham. Hold on, Ms. Denham. I'm going to ask you a question. Okay, can we unmute Ms. Denham, please?
Your Honor.
Yes.
She's gonna have to put on a t-shirt or something. I'm in here with inmates. She's got.
Okay. You're gonna have to, you have a jacket, Ms. Denham?
Yes, sir. I'll go get it. No, I can cover up right here. I'm sorry about that. My mom called me and told me to join the meeting because I take care of him. Hold on. Okay, I'm back.
Okay. Were you present on June 25th at 2024 when this incident happened?
Yes, sir. I got a call from my uncle stating that him and the lady was
No. Were you present at the scene of where this allegedly happened?
No, sir.
Okay, so you don't have any firsthand knowledge that you can tell me about. You're gonna tell me what somebody else told you.
No, nobody didn't tell me this. My uncle called me for help. If you go back into the police reports, you will see that I had been calling for a week straight trying to get him out of the house. Andrea Tabb would not open the door. I had to call the police several times, even senior affairs, about this case. When she found out that I was moving into another location and she wasn't allowed there, that's when the fight broke out. The two people that are talking, Christian and Lakeisha Moore, they actually have all my belongings. They was looking at my uncle as a dollar sign. They have all our belongings there. They would not give it to us. And so he was stuck in there. They wouldn't even unlock.
So I'm done with Ms. Denham. Thank you. Anything further?
No, Your Honor, just to go back to, our point was simply that what lesson he will learn from extra jail time could be served by, say, 20 or 30 days instead of 75.
Okay. It will be the court's a sentence. If he chooses to accept it, it will be 120 days to serve. Credit for time served 15 days. Do you need to speak with him, Mr. McLean?
I don't believe so. I think we covered all the bases in our discussion yesterday. I told him there would be a flexibility, there would be a range. And do you understand the math, Mr. Ingram? This would cause you to spend 45 days extra. 45 days from today, you will be put out on probation. Go to 132 Mitchell Street, JCS probation, and get your instructions on how quickly you must start FVIP and the 40 hours of community service. And I'm sure at the hospital, Grady, you can get the alcohol and drug evaluation as we discussed. So it'd be 45 days extra by the math that I'm doing. Do you understand? Is this what you want to go ahead with?
Medical, you have to unmute for us.
What did he say?
And Your
Sir,
Honor,
could you repeat that again?
okay, the judge is saying that he has heard everybody and believes that 45 days extra would suffice the jail portion of your sentence if you stick with your plea. You will, of course, do the FVIP in the 40 hours and the alcohol and drug evaluation and treatment if recommended, as we discussed.
So I will get out in 40 days.
It would be 45 days from today. That's a month and a half.
A month and a half.
Right.
Okay. All right, sir. I agree to that.
Okay.
All right. If nothing further, Mr. Ingram, it's my understanding that in case 24 CR 004157E, you wish to plead guilty to battery family violence. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
I mean, sir, Your Honor, sir, I got the longest that in that apartment. I don't want my stuff on the street, you know, and then I'm missing my credit card. I don't know where it's at.
Mr. Ingram, the judge did me on those points. He did understand our point.
But I mean, everything I put my money into, it's gonna be on the street. You know.
Well, it appears that you have. It appears that you have a caregiver there that can, you know, help you out with that if need be. So it sounded like you had an advocate there that might be able to help you out with retrieving your belongings. So
That's not the case.
All right. Well, it's not the case. He'll have to figure out another way.
They won't let her get her stuff. They won't let her in the apartment to get the stuff. They won't
Well,
let
you'll have to figure that out.
I believe you could have a one-time, you or a friend or relative could have a one-time police escorted visit to get stuff out.
Sir?
Your personal belongings could be in a one-time police escorted visit for that purpose. Usually the police are busy.
That'll be like 45 days from today. I mean, I haven't even paid rent for this month. So, I mean, they're gonna put my stuff on the street. I mean, you know, I don't understand, you know, that the police wouldn't even talk to me, ask me what happened. All they doing is going against what some more people said, that witnesses. That
No, I believe I discussed this with
she
him.
went to no hospital or nothing to get
I'm not sure.
I mean,
You need to. Okay, Mr. Ingram.
I need a
So-
breakout. I need a breakout room with him, Your Honor.
No, well, no. I'm gonna reset this. I'm gonna reset his case for a week. Medical, would you please mute for me?
Yo, not trying, man.
All right, I'm gonna reset his case until 7/16 to give you the opportunity to figure some of this things out for him, Mr. McLean.
Correct, Your Honor. Thank you.
Remind me of next week of I'll still be willing to do what I said I'm gonna do, but I think you need, if he's gonna take a plea, then you need to advise him and maybe assist him.
I agree. Thank
All
you.
right. We're done with Mr. Engel for this morning. I'll see him back next week. Who do we have next?
Your Honor, we can go to position number 22. That's when we missed
Okay.
it. Reginald Hendricks. I believe so, right? Yep.
Yep, come on. He's here in the courtroom. That's a negotiated plea.
And Your Honor, I do have some information on 22 that may affect the negotiated plea. The state's recommendation was 90 days, but we miscalculated the credit for time served. It should be 39 days, which would be from June 1st of 2024 to today, which would increase the amount of time he has remaining. And I do apologize to the PD's office for the miscalculation in the time. I accidentally doubled it.
I'm sorry, wouldn't that be extra jail days of 6 days? The way you calculate it?
That would be correct. It would hold him in jail for another 6 days.
I told him in our discussions yesterday, I said, I think there's an obvious math error. I believe the recommendation is going to be 6 extra jail days and all the conditions of probation. He understands.
Thank you. And Ms. Burke is here and would like to speak in regards to this case. I will place the recommendation on the record. It was 12 months served, 90 days, credit for time served, 39 days. That's from June 1st of 2024 to today. Balance probated. No further contact with Talisa Burke. We are also asking that the defendant stay away from 150 Dahlia Avenue, Northwest in Atlanta, Georgia. We did have an opportunity to speak with Ms. Burke. She did send us some information. It appears that this incident has been an ongoing incident for several months where the defendant has been coming to her house, ringing the doorbell repeatedly. It started back in, according to the documentation she sent us, Your Honor, she had purchased the home around 2020. This incident started in February of 2024. The defendant would show up asking for her phone number, asking where she worked. She would start ignoring him and just kept trying to move on. The defendant then escalated in May of 2024 by going to her house, knocking on the doorbell, ringing her doorbell, knocking on the door for approximately 3 hours at a time. At that point, he was given a criminal trespass warning. Ms. Burke also filed for a temporary protective order. On May 18th of 2024, the defendant came back to the residence, was on the patio and knocking on her bedroom window. That then prompted the police to come back out on June 1st. The defendant was on her property looking into trash cans after staring into her front yard for a few minutes. At that point, she did call the police again and the defendant was arrested. This case was originally charged as an aggravated stalking and then for whatever reason was downgraded to a stalking by the DA's office and sent to our office for adjudication. We would like at this time to sound for Ms. Burke, and we would ask the defense to stipulate to venue factual basis and identification for the purposes of the plea.
For said purposes, we do so stipulate.
I think we've gotten just a bit ahead of ourselves. Good morning, Mr. Hendrick. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you, sir. You can place your hand down. Ms. Burke, good morning. Thank you for being here. If you would like to address the court, now is your opportunity to do so. If you would like to, I'll need for you to raise your right hand for me. The other hand, please. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, I do, Your Honor.
Okay. Yes, ma'am. What would you like to tell the court?
Everything that was stated by Mrs. Falk is true. I did not know Mr. Hendricks prior to this. The address 149 Dahlia Avenue is directly across the street from me. So this has caused a lot of stress for me. And if he is released, I'm pretty sure he's going to come back and he's going to do the same thing. On the May 1st date, the officer talked to him for quite some time and had it recorded. Do not come back on our property. I told him this. So my concern is, number one, If he gets released, he's going to come back to the property. The other thing that I would like to state is that all the windows have been broken out from this property, and I'm not sure if he's even a resident at this property. And based on the July 1st law, I would like for him to be able to prove that he is actually a resident of 149 Dahlia Avenue in order for him to be able to come back.
Okay, Ms. Burke, has he been, what has he been doing on your property?
Walking around. So on the May 1st day, well, before that, let me not get ahead of myself. He would come over and knock on the door or be in my property, walking over saying, hey, what's your name? I'd like to get your number. May I talk to you? I have told him repeatedly, I'm not interested. I do not want to talk to him. He asked me, where do you work? I did not provide a response to him. He has asked me before, because I had someone there, hey, I'm not worried about that guy over there. Will you give me your number? You're going to give me your number. On the May 18th date, he was knocking on my bedroom window, which is behind the house. That is why this is really cause for concern for me. I do not know this man. I do not know why he will not understand that I don't want to have anything to do with him. I am fearful and I'm scared that because this has been escalating from him yelling across the street to coming on my property to knocking on my door, ringing my doorbell at 2, 3, 4 a.m. in the morning to coming behind the house and doing that at 3 o'clock in the morning, that because this has escalated, what else is going to happen if he's out?
Thank you, Ms. Burke. I appreciate you being here today. Ms. Falk, what is Mr. Hendricks's history, please? Do you have that for me?
I do, Your Honor. And also, the court does have the option with this offense to issue a permanent protective order to the victim in this case. And given the circumstances of which the state became aware of after the the victim, where she kind of let us know the extent of this issue, that may be a better response instead of just a stay away order for the 12-month period. There was a criminal trespass. The defendant actually has, and let me just go through, has 52 cycles, Your Honor. That includes the aggravated stalking case, which was moved down, a open 2021 family violence battery case, as well as a theft by taking case from 2023, where he was sentenced to 5 years, serve 5 months, and criminal damage to property. The 2017 failure to appear, a disorderly conduct from 2017. It looks like a drug case from 2017 where he got 1 year commuted to time served, and a marijuana case from 2017 where he received 10 days of confinement. He also has, a probation violation from 2015. Those are all the cases that I'm seeing, and a 2012 possession of marijuana where he was sentenced to 5 years suspended. Those are all the charges that I'm seeing that were resolved within the last 10 years.
Okay, and based on what you've heard, is the state requesting that the court issue a protective order?
Yes, Your Honor, the state would request a permanent protective order, and I can send that over for the court's signature.
Okay. Mr. McLean?
Your Honor, as I said before, for the purpose of the plea, we stipulate to the terms. And we'd like to ask the court to accept the negotiated plea.
Okay, I'm not inclined to accept the negotiated plea. Mr. McLean, I'm inclined to not only issue a permanent protective order, but I think that something else is going on with Mr. Hendricks. I would also require that he have a mental health evaluation and any treatment that may be necessary in addition to the no further contact and stay away. At this point in time, it does not appear that aside from no further contact, that there are no other terms of probation, but I would add a mental health evaluation. So
I believe you could obtain that, Your Honor, at 10 Park Place. I believe that would not be difficult to get.
Okay, so So as I said, I would not accept the negotiated plea. Do you need to speak with him about the additional terms?
If we could go on mute, and turn away for a moment. Yes, Your Honor.
Okay.
Your Honor, he does have resources available through the Grady system. 10 Park Place would be the appropriate place to go. He understands his need to do that if the court adds that as a condition of probation. The evaluation with the treatment if recommended.
All right. Is he ready to go forward with the
Yes,
plea?
Your Honor. He is.
Thank you. Mr. Hendricks, it's my understanding that in case 24 CR 004140C, you wish to plead guilty to stalking. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I will accept the plea, Mr. Hendricks. The court sentence is going to be 12 months. Probation to serve 90 days, credit for time served 39 days, the balance probated, a mental health evaluation, and any treatment that's necessary, a permanent protective order for Ms. Burke. Stay away from Ms. Burke's resident at 150 Dahlia Avenue. No further contact with Ms. Burke, and no drugs, alcohol, or weapons while on probation.
Yes, sir.
All right. Good luck to you, Mr. Hendricks. You also, Ms. Burke.
Thank you, Your Honor.
Thank you, Your Honor.
Position number 11, Carol.
Okay, and this is going to be a waiver, is that right?
Waiver of arraignment, Your Honor, not guilty. He does have a bond request, I believe.
Okay. Good morning, Mr. Carroll. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Say that again.
You're doing this by video. Is that okay with you?
Yes, sir.
Okay. Let's see. Is there a history, Ms. Tyson?
Yes, Your Honor. 6 arrest cycles beginning in 2020. Misdemeanor conviction out of Lovejoy Municipal Court for marijuana possession less than 1 ounce and misdemeanor willful obstruction. That's from July of 2023. Received probation for 24 months, a fine, and 40 hours community service on that case. He has another misdemeanor conviction out of Clayton County for criminal trespass. And that's from August of 2023, where he received 12 months probation, a fine. And it looks like he has community service on that case as well. He has another misdemeanor conviction out of Clayton County, criminal trespass, theft by shoplifting. That's from August of 2023. He has a fine, community service, 12 months probation on that case. And his last arrest was in Clayton County, July 17th of 2023, and that was for a failure to appear. Nothing to add, Your Honor.
Ms. Falk, what are the current bonds?
Yes, Your Honor. My apologies. I was sending over that permanent protective order to Your Honor and lost my place. Which position is this?
This is position 11. Mr. Carroll, he's filed a waiver, and Mr. McLean is making a reduction and modification. of bond.
Right. So the bond currently set on this, Your Honor, is $2,000 surety bond. That was set by Judge Williams on June 25th of 2024. That was for the reckless conduct and discharging a firearm. So that is the current bond that was set. Let's see. The state is asking that that bond not be amended or changed, not only based on the history that Your Honor just heard, but based on the facts of this case. This incident happened back on June 23rd of 2024. The officers were called out to, let's see, it was 1073 Piedmont Avenue Northeast, which was Piedmont Park, in regards to shots fired. The victim, Mr. Vincent Sutherland, who worked security at that location, stated he heard 2 to 3 shots being fired within the park. They went into the park, observed the defendant walking around the parking lot with a loaded handgun. They, at that point, drew their weapons, told him to drop the gun. He did and was placed into custody. He had marijuana on his person, an amount less than 1 ounce. The gun had a 14-round magazine with a bullet in the chamber and 5 .40 Smith & Wesson hollow point rounds. The officers then called Mr. Sutherland out, who's the security guard. He recognized the defendant. He told him he was trespassing at the park and had to leave at 11:03 p.m. Less than 2 minutes later, he heard shots go off within Piedmont Park, which is the last location he saw the defendant in. The defendant was intoxicated at the time he was arrested. He stated he was drinking in the park area, and that's when he was taken into the jail. So the state does have some really serious concerns given the events that happened that evening, especially somebody firing a handgun inside Piedmont Park, even late at night, would cause a great amount of consternation for everyone involved, including the security guard, which is why police were called out. And, you know, the defendant walking around a parking lot with a loaded handgun drawn is definitely a cause for concern. That plus the fact that the defendant has a failure to appear on a felony charge out of Clayton County in July 17th of 2023 and a previous criminal trespass conviction in Clayton County in August of 2023, which would still be open because he was given 12 months probation. The state would ask that the bond remain as set.
Mr. McLean?
Your Honor, the $2,000 surety bond would mean that he could go to the bonding company. It would cost him several $100s. Your Honor, factually, he intends to prevail at trial. There was a misperception as to what occurred and who was responsible for what, and he will be vigorously defending this factually. He would like to ask the court to consider a signature bond, and he promises to faithfully be in court on time.
I don't see that any circumstances have changed since the SEA calendar. I actually think that this is a low bond from what I've heard, so I'm not inclined to modify it. Good luck to you, Mr. Carroll. Who do we have next?
Position number 25, Corey Jackson.
25. Jackson.
This is Mr. Ty's case.
Yes, Your Honor.
And you're filing a waiver. It says that you need additional discussion. Do you still need additional discussions with Mr. Jackson?
Your Honor, I did want to make a bond argument and then may need more time to speak with him after that.
Okay. Good morning, Mr. Jackson. I'm Judge Eric Morrow. We are conducting, this is a state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Let's see. Ms. Tyson, do you have Mr. Jackson's history for me, please?
Yes, 1 moment. Looks like he has 10 arrest cycles beginning in 2008. Last arrest was in Atlanta, February 2nd, 2024. For battery, family violence, first offense, criminal trespass, and cruelty to children in the 3rd degree. Give me 1 second. I believe that case is pending. Let me open it.
Oh, here we go.
Yes, that case number is 24 CR 000-603E. Looks like it's assigned to Judge Morrison. Let's see. Here.
You see it though.
He has a probation violation. Let's see, from 2013. So looks like no, and a failure to appear from 2012. No convictions, no felony convictions, and no other convictions within the last 10 years, Your Honor. Nothing to add.
Thank you, Ms. Tyson. Ms. Falk?
Yes, Your Honor. Just to give you a brief overview, this does also involve the open case that was also placed on the calendar, the one that pretrial just cited to. The defendant in that case was charged with family violence, battery, cruelty to children in the 3rd degree, as well as, let me just look at the last charge on that, criminal trespass and damage to property. Those charges involve the same victim. That's the victim in our case. The defendant was given a $5,000 surety bond on that case on February 3rd of 2024, and was ordered to have no further contact with our victim, as well as stay away from the address. Let's see. That then led to this case. The state has modified the case from a simple assault to the correct charge, which was a simple battery. So we have amended the accusation on that case just to draw it to Your Honor's attention. The $5,000 good bond that was issued May 3rd of 2024 was issued by Judge Mincy, and that was a $5,000 surety bond, no further contact with Miss Ghani and the minor child, SG, stay away from 115 Rumson Road. The incident that happened on this newest case involved, as I stated, the same victim. In this case, the defendant, just pull that up really quickly. In this case, the defendant on June 24th of 2024, which was approximately 4 months after the first case, went back out to the address that he was ordered to stay away from, 115 Rumson Road Northeast. Officers spoke to Miss Ghani, who was the person he was ordered to stay away from. She said that she was with the defendant. He said something clever. She didn't hear what he said. She asked him to repeat it. He refused. They then got into a verbal argument. He pushed her off the bed. She got up, asked why he pushed her. He pushed her again. She stated this is not the first time the defendant has gotten physical with her. And when officers looked up his history, they saw that he had the previous case. At that time, he was placed under arrest. The defendant had in his possession in a black crossbody bag, he had a iPhone, wallet, keys, and a STR-9C handgun, which, if Your Honor knows, the previous bond conditions include no drugs, alcohol, weapons, or firearms, which is very clearly stated on the previous bond order from February. So not only did he violate the stay away order, he violated the no further contact order. He also violated the no firearms, alcohol, drugs, or weapons order. So there's literally not a single part of this order he didn't violate within the 4-month period. For that reason, the judge ordered a $5,000 cash bond on this case, being that it was just a continuation of previous violence against the same victim and a violation of all of the previous orders against this defendant. For that reason, we are asking that that bond remain the same. The defendant has already been given a bite at this apple, was given a $5,000 surety bond, did not adhere to any of the conditions listed in that order. And for that reason, Judge Mincy on June 26, 2024, since he had already violated her previous order, gave a $5,000 cash bond. And we ask that this court respect the recommendation of the previous judge who has dealt with both of his cases in giving that order, and that it remain as set. We would too at this time like to sound for Yanira Ghani, if we may.
Ms. Ghani is present and wishes to address the court. Now is your opportunity to do so. Doesn't appear so. Mr. Ty?
Yes, Your Honor. My client is 34 years old. He has lived in Georgia for 17 years. He's been employed for the last 10 years at Artisan Custom Closets, designing and building custom closets. He does work to support 3 minor daughters who he is an active father to, and he supports financially. I spoke, and Your Honor, I would just like to first state that he didn't violate the stay away. The stay away in the original order was 5675 Roswell Road. I believe that he was not at that location. Yes, there was contact, but I believe he was living at the Rumson Road address, and that was not the address where he was supposed to stay away. The address where he was supposed to stay away is listed as 5675 Roswell Road. I spoke with the complaining witness yesterday. They do share a child together. She states that for the simple assault, family violence, which has been amended to simple battery, she does not want to press charges. She states that she does not want him in custody. She does want him to have contact with his child. She tells me that she's being evicted due to lack of financial support. She told me it's since she's being evicted that he wouldn't even know her address, and that she only wants to have contact with him through a third party so that they can continue to co-parent. His sister, who moved his things out of the apartment that Crystal Jackson, she is on the line. He's going, hopefully, if he can get out with a reasonable bond, he's going to be living with her. She's on the line. He does have family support here. He has strong ties to Georgia. He's been working a steady job for the last 10 years. He has no reason not to return to court. And have no contact. He'll have no contact with Miss Ghani. And Your Honor, I would just like to point out that at first appearance, the state did request a $5,000 surety bond. And that's all I'm asking for today, is for the state to consent to a $5,000 surety bond, which was the original request by the state at his first appearance.
And Your Honor, I'm not sure which one she's referring to, the first crime or the second crime. I will say that
he's here for now.
I will say that we did send Your Honor a copy of that bond order, as well as Ms. Atai, from the February 2024 hearing, where it clearly states under other, stay away from 115 Rumson Road. I'm not sure which address Ms. Atai was seeing on that order, but the order does clearly state, which I've sent to both PD Atai and to yourself, that it was this same address that he violated the conditions of bond that he was at again. I will state also in my place that we had an opportunity to speak with Ms. Ghani on July 8th, 2024. She is in agreement with the plea offer that has been made by the state.
I spoke with her today.
I understand. And as I said, she was in agreement with the plea offer that was made by the state yesterday.
Okay, so you'd like for me to hear from Ms. Jackson, Ms. Atai?
Yes, Your Honor, this is his sister who he will be living with. And yes, she has joined the call just to show support for him and state that he will be having a stable address with her.
So, Ms. Jackson, I'm glad to have you here. If you would like to address the court, now is your opportunity to do so. If you would like to address the court, I'll need for you to raise your right hand. Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can place your hand down. Thank you, ma'am. What would you like to tell the court?
Well, I don't know if I'm at liberty to say this, but the reason why he was in contact with her is because she's being evicted and he was helping her get another place, you know, not just for their daughter, but also for her to have a roof over their head. So that's the reason why he was around. I don't know if I'm at liberty to say this at all either, but she was upset that he was leaving from her place.
Your Honor, again, I'm going to object to this line of, to these statements, especially ones that put words in Ms. Ghani's mouth. If Ms. Jackson was not present at either incident, and she apparently does not have any relationship with Ms. Ghani other than the sister of the defendant.
Okay, so don't tell me anything that she said, Ms. Jackson. But if you have something that you'd like to speak on as far as your brother goes, then I'm happy to hear it.
Okay, so these are things that she said, and I did swear to tell the truth.
Okay, but even though you swear to tell the truth, there's still hearsay. Okay, so
Gotcha.
okay,
Okay, but their daughter is at my house a lot. So he does take care of them. He has 2 daughters. He takes care of both of them, and I also help him with taking care of them. He is a good father. He works a lot every day. He's a hardworking man, and I don't know if you can object or whatever, but I have his phone. And he was recording the whole time he was over there, and he told me to look
Your
at
Honor,
it.
I'm going to object respectfully again to her testifying to what is on his phone.
Okay.
So just tell me anything else you want to tell me as far as your brother's situation goes that you know firsthand.
Okay, so firsthand, what I'm going to say is before anything, he's a father. So if he have to break any rules to be a father, then that's probably what he's going to do, you know, to help out his child who's in need of having a roof over her head. So if he have to go over there and, you know, take her food because she's hungry, you know, he's going to do that because he is a good father before he's anything.
Okay. Thank you, Ms. Jackson. I appreciate you being here today.
Your Honor, and I'm sorry, that's right about the Rumson Road address. I'm just looking at what's on the calendar. And it says 5675 Roswell Road. So I thought that would be the same address from the previous order. Okay. And the current order is asking for a stay away from 5675 Roswell Road. So I don't know whose address.
Well, he knows that he's not supposed to have any contact with her. So regardless of where he's supposed to stay away from, he knows that he's not supposed to have contact with her, and had he not had any contact for whatever reason, he wouldn't be back in this situation. What does concern me also is that there was a gun involved, and he's not supposed to have any firearms while he's out. So he has violated the terms of his first bond order. Both of these bond orders were issued by the same judge, Judge Mincy. She chose to issue a $5,000 good bond for whatever reason on the first order, and I can understand that if he came back before her and on the second order that he increased, that she would not go with the $5,000 good bond because she'd already given him one and he violated it, so she went with a $5,000 cash bond. I'm not going to, given the circumstances, and you understand that you're not supposed to have any contact whatsoever. I understand the issue with your child, and I respect that, but that's going to keep putting you back in the same situation that you're in. You can have your sister be an intermediary, someone else be an intermediary, but if you all can't stay away for whatever reasons, you're gonna be right back in the situation. I am gonna respect Judge Mency's orders. She's handled this case on 2 occasions. And she felt that these were reasonable bonds. I have not certain, I heard a change of circumstance, so I'm gonna let her bond stand at the present time.
Okay,
Thank you, Your Honor.
Your Honor, but I did speak with my client. He is desperate to keep his job. He's had it for 10 years, and because he is, skilled at what he does, that he hasn't lost it yet, but he will if he stays in jail any longer. So he did state, again, the state has made a global recommendation, and which includes extra time served on the charge that he's not currently being held on. He currently is only held on this $5,000 cash bond. I mean, that's like a $50,000 surety bond, Your Honor, for a simple assault turned simple battery family violence. And if there's nothing that we can do about the cash bond, then my client is prepared to plea to only the charge that he's currently here for, which is 24 CR 4146E.
Okay. Recommendation on that charge is 12 months to serve 30 days, credit for time served 15 days, no further contact.
Yeah, and I understand, Your Honor. I apologize for interrupting. Please continue.
No, I'm just trying to figure out what the recommendation for that one charge is.
Well, therein lies part of the problem. The state's recommendation totally was 24 months, serve 180 days. And so given the fact that this is proceeding as a non-negotiated plea, this is the second offense by this defendant against the same victim, and the fact that he was in possession of a handgun at the time the second incident happened, we would ask for 12 months with 180 days to serve, credit for time served 15 days. That's going to be from June 24th, 2024 to today. Balance probated, no further contact with Yanira Ghani, stay away from, and I believe this is her new address. And so let me just get that updated information from Ms. Maldonado. And then no firearms as well. We are also going to ask for a family violence intervention program, since this is a simple battery family violence and it would fall under the family violence intervention statute, which was a part of the second case. But since he has to do FVIP on a case of family violence, we would ask that it be set on this case.
Mr. Ty?
Your Honor, of course, we would object to anything that requires him to serve any more time. He's willing to plead guilty in order to get out to keep his job. So the 30 days credit for time served, 15 days, we have no objection to no further contact and a stay away. This Roswell Road is not, I don't know whose address that is, but no further contact with Ms. Ghani. And I understand that it was a global recommendation, but I think for a simple assault turned family violence for the state to request 180 days is unreasonable.
And Your Honor, it is very reasonable based on the fact that defendant was in possession of a firearm on this incident. He violated the terms and conditions of his previous bond on this incident, and the fact that defendant had a previous arrest from 2014 for family violence battery that was then dismissed. So given all of, if I may finish, PD Atai. Given all of those circumstances, that was the basis for the state's recommendation.
Okay. So, Mr. Ty, I'm not willing to change the bond, to modify the bond. After all I've heard this morning, if he wants to have a global resolution, the court sentence would be 12 months to serve 90 days, credit for time served 15 days on both. I can't give, this is because of the posture of this, and he'd have to have the family violence intervention and all the rest of the conditions as well. But if he wants to consider 12 months to serve 90 days, credit for time served 15 days, that would be my sentence on both charges. Do you need to speak with him about that?
Yes, I would need to speak with him.
Okay. Do you want me to reset this to give you an opportunity to speak with him to explain it all until Thursday or until next week?
I don't think it needs, I'll speak with him now if that's okay.
No, that's fine with me. I just want to make sure that you have adequate opportunity to explain everything you need to him. But if you want to speak to him today, I'm happy to allow you to do that.
Thank you.
Okay. So, can we have Mr. Ty call medical, please? Or do we have others that we need to address there?
We got Patrick, but he said he want to represent himself. Take it down right quick. Go ahead. Come on.
We have who?
Patrick, he's position 37 and 38.
Okay. So who's presently representing Mr. Patrick?
Said somebody by the name of Moses Conflict. He said he wanted to represent himself.
I can't get in contact with Moses, but Mr. Moore, I choose to represent myself today.
As we've been trying to reach his attorney, Mr. Moore, apparently we have not had no answer. This case has been reset from last week. Mr. Moore did not appear, and he's not answering, so I don't know if he's still on the case or not on the case, apparently, but he's not responding to none of our emails.
He's not filed a withdrawal or anything of that nature? Ms. Lewis?
What, we say that again, Judge?
So was there an entry of appearance filed at some point in time?
Yeah, Mr. Moore did file an entry of appearance, yes.
Okay, and you have not been able to contact him since last week?
That's correct. File leave of absence, but let me double check the dates on there again.
And where's Mr. Patrick? Is he courtroom 2 or medical?
He's in medical.
Medical.
Okay. Mr. Patrick, good morning. I'm sorry that we haven't been able to get in touch with your attorney. The state is requesting quite a bit of additional time in your case. Your attorney has not withdrawn from your case, and as such, he represents you. I don't feel comfortable taking a plea from you while you're still represented, especially given that it involves additional time. I think what I want to do with your case this morning is that I want to vigorously try to get in touch with your attorney and see what we can do in the next 2 days, okay? So I'm going to place your case back on the calendar on Thursday so that hopefully we can get in touch with him by that time. Have you been in touch with your attorney at all, Mr. Patrick?
I talked to my mom, and my mom said he's really just thinking about representing this case right here because he represents another. So my mom was saying it was in my best interest for me to get a public defender. But
okay.
I talked to him to try to get him to represent the case, but he's kind of, you know, he's skeptical about it because he feel like I might get in trouble again, I guess. I don't know.
And Judge, he's not being held for this charge either. This is the battery charge. He has felony hold, so this case is not keeping him in jail.
Okay, so I'm going to try to get you I'm going to try to get him to withdraw because he's already filed a notice that he's representing you, Mr. Patrick. So I'll try to get him to file a notice that he's going to withdraw, and then I'll have you make application for a public defender, or we'll get a public defender to represent you. Okay. Medical, you have to unmute. I can't hear. Yes.
even though like that was going on, am I allowed to hear on like the offer anything? Not saying I would accept anything, but can I like hear what's the recommendation, anything?
Okay, you were charged in case 22 CR 004680F with battery, and in case 23 CR 005829F with reckless conduct, discharge of a firearm on property of another, and theft by receiving stolen property. And I'll let Ms. Falk, if you would, Ms. Falk, go ahead and let him know what the state's recommendation is. You're on mute.
On position 37, the battery, the state's recommendation is 12 months probation, 30 days to serve, balance probated, 8 weeks anger management, no further contact with Jakia Bessie May. On the second case, position 38, the count of reckless conduct, the state's recommendation is 12 months probation, serve 180 days, credit for time served 2 days, balance probated, no firearms, 40 hours of community service. Count 2 would be 12 months probation with count 1, which is discharge of firearms on property of another. And count 3, the theft by receiving stolen property, would be 12 months concurrent with count 1. No further contact with Reginald Folks. Your Honor, I will place on the record that the defendant does not appear to be in jail on our cases. Rather, he's in jail on 24 PI 004268, which looks like a theft by taking possession of a firearm, and I'm not sure if that's by a convicted felon or not. Bond was denied by Judge Oliver on that case.
Okay. So you're not being held on these charges that are before us today, Mr. Patrick. But again, I'm going to reset your case and you've heard the recommendation. I'll reset your case until next Tuesday. To see if we can get in touch with Mr. Moore Moses. And hopefully we'll be able to move the case forward at that time, okay? So I'll see you back next Tuesday.
All right, thank you.
You're welcome. Who do we have next?
It's gonna be position number 35, Mr. Chad Murray.
I have that he was accepted to PAD.
He was, Your Honor, and Pat is here today, just to verify that. Ms. Falk, I did just kind of re-up in your email, a previous email chain. On June 27th, ASG Ham did agree to divert this case because of his acceptance to PAD. He had a felony matter he needed to resolve, so Judge Law reset the case so that we could discuss a release order to PAD. He did have that felony hearing on July 5th. And it does still show that it's holding him because the probation officer still has to submit the paperwork for that. But I did get confirmation today from his felony attorney that he was continued on that felony probation. So I know I'm kind of giving you a lot of information, Ms. Falk, to get up to speed, but I think that's where we're at. So Pat is here. He was accepted. This incident is the direct result of homelessness. He's been homeless for the past year and a half, and so he's really excited to work with Pat and try to address the homelessness and the underlying reasons. He's a super employable guy. He does drywall, tiling, landscaping, things like that. So I think that Pat would be a great option for him. I'm
You're
sorry,
on mute.
I'm mute.
Keep putting myself on mute. So I'm just checking because of his FTAs. He may only be eligible for a pretrial services bond. And so I have spoken with Pat about this, and the fact that SB 63 does have the effect that anybody released to PAD would have to be released through pretrial services bond. My last communication with PAD was that they declined to accept people released on a pretrial services bond. I did explain that that was not the state that was, quite effectively the law now as of July 1st of 2024. And I'm not sure. I believe we may just be in an impasse. The state did not create the law, but we do have to enforce it. And so I just need a moment, if I may, if, you know, given all this information, if I may, to just look and make sure he would qualify for a bond outside of pretrial services. I don't believe he does, just taking a look at his history.
Okay.
And I do see your email from 10 o'clock this morning, Ms. Micheletti. I did not have an opportunity to look at that since I'm the only one handling court today. So if I can just take a moment to look at this, speak to Mr. Ham, see if he did agree to divert this case, since I absolutely have not had a chance to follow up on any of this information.
Extremely understandable. Thank you.
Thank you. And Your Honor, I can review this if Your Honor wants to move on to another case. I can review this while we address another case, if that would just be easier for Your Honor.
Okay, there's some that I want to address that are conflict and Ms. McLeod's cases, reset them. So let me just go ahead and do that. Position number 36, Chronicle Odom. Ms. Lewis, were we able to get Mr. Odom a conflict attorney? Ms. Lewis, are you with me?
One second, Judge, please.
Hi, Judge. I'm sorry. I was on the call with Mr. Moore. I finally got in touch with him.
Okay. Say it again.
I'm sorry, this is Katrina. I was on the call with Mr. Moore, the attorney for Mr. Patrick.
Yes.
I got him on the line now, but Ms. Strong told me you got a question on position 36.
Yeah, I just want to reset some cases, and if you'll just let that attorney know that we have to know whether or not he's going to represent and if or withdraw from that case. But on position 36, Mr. Odom, were we able to get a conflict assigned to his case?
Yeah, Ms. McLeod.
Okay, so Ms. McLeod's not available, I think, today. We're going to
No,
reset.
she's not.
Okay, so we're going to reset Mr. Odom for 7/16, a week out. For positions number 29 through 34, which are also Ms. McLeod's cases, we'll reset those for a week out also to 7/16. And positions number 19 and 20, also Ms. McLeod's cases. If we can reset them also to 7/16. Okay. Are there any other cases? Who do we have in medical?
And Your Honor, the state is ready on Mr. Murray's case when you are.
Okay, so why don't we bring him back up? Yes, Ms. Falk.
Okay. So the issue appears to be with the new law that's in effect under 17/6/12. B1D. It says that a unsecured judicial release can be ordered unless the defendant had a bench warrant issued for his arrest for a failure to appear in court within the past 5 years. The problem that we have in Mr. Murray's case is he's had 3 failure to appears issued for him in the past 5 years, which would then make him ineligible for unsecured judicial release. It would make him eligible for release through pretrial services. And as I've explained to PAD is not, unfortunately, a pretrial diversion or pretrial intervention program under Article 4, Chapter 3 of Title 42, Article 4, Chapter 18 of Title 15, or Uniform Superior Court Rule 27. So at this point, because of 17-612, the only recommendation I can make on his case is just to have him do a pretrial services bond. Now, if Pat is fine with taking him on a pretrial services bond, the state is more than happy to agree to one. But so far, in our conversations with Pat, they are not agreeable to that, and I can't change the law.
Yes, and do we have a PAD representative on? Ms. Hybel, if you all can just confirm that you will or will not accept him on those terms.
Hi, Your Honor. Sorry. I'm gonna go ahead and say we won't, just because I don't personally know. My boss is the one that does all of this, and I do know with the new law, everything has changed, but I am gonna go ahead and say no, that we can't if it's pretrial.
Okay. And would you do the court a favor and speak with, because this won't be the only time that this comes up. If you all could get speak and just get us a global acknowledgement of what you will or won't do, if you all can just talk about it, and if you're gonna continue not to accept people that have pretrial, let us know so that we will know going forward. Okay.
Yes, absolutely. Thank you.
Okay, thank you. We appreciate it. Okay, so given that, is he being held on this, or?
Yes, Your Honor.
Okay, so we can and he's on a surety bond?
Yes, Judge.
So you want to convert the surety bond to a signature bond through pretrial level 1 with whatever conditions were on the other bond.
Okay, thank you, Your Honor.
Okay, now does he need assistance through a social worker with help?
I believe, and Ms. Hybel, I guess, can you help me understand? He was accepted before this happened. He self-referred to PAD and was accepted. Could he still come to you all for housing assistance? I know that was his plan, or do we need to make an alternative plan?
I would say he can come and get some services, just because in my experience, and I know with the new bill and stuff, we do take I've taken people pre-trial, so that's why I'm just like, I'm sorry, I don't really know for sure, but yes, I would.
I hear you, and I'm trying to make sure nobody here's in trouble. So he can't be released to you for diversion through pretrial, but since he's already been accepted into the program, he can still come to you for housing assistance if he's released separately.
Yes.
Okay, so I think then, Your Honor, I think we have a plan for getting him some housing, and I'm also going to give him my contact info, and I'm connected elsewhere. So I think we have a plan for.
Okay, all right, excellent. Mr. Murray, good luck to you, sir.
Thank you, sir.
Thank you, Your Honor. And thank you, Ms.
Okay. Who do we have in medical?
This is position number 39 through 40, Mr. Jarrell Riley.
Your Honor,
Okay. That's a negotiated plea?
Yes, Your Honor. But I did want to address position 25 first.
Okay.
He understandably is very hesitant to agree to serve another at least month in jail. So I am resetting him for a week. But I did want to ask, if the state would consent and your honor would consider a $10,000 surety bond for the simple assault turned simple battery family violence that he's currently being held on.
I believe the state had pretty much laid out our recommendation, which is to remain on a $5,000 cash bond. I understand what PD Atai is asking for, but given all of the circumstances, the state does have some serious discomfort with him being out on another surety bond after having violated the first surety bond within a 4-month period.
Well, your honor, just the sister stated that she was desperate, being evicted from her home, and he was just there to offer, but he didn't even offer his help. She came asking for his help.
And your honor, the sister also stated that he would violate the bond again if necessary to go back to that home. And so the state does have some serious hesitation about just giving another surety bond on top of the existing one that's already been given.
She stated that he's a devoted father.
Okay. We've already gone down this road, and I appreciate your advocacy, Ms. Atai. I've made the decision with that regard. So
okay, your honor, so he's gonna try to do what he can for the $5,000 cash bond. But your honor, the offer was 90 days, credit for time served 15 days, FVIP, and 12 months of probation and that's what you would address as a global recommendation.
no, that's what the sentence would be, as a global sentence.
For both.
For both.
Okay. Thank you, your honor. So
okay, so you want to reset him position 24 and 25 until when?
1 week, your honor.
Okay. So we'll reset him until 7/16. Okay, and so now we're on Mr. Riley, position 39 and 40. Good morning, Mr. Riley. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
And that's a yes, Mr. Riley?
Yes.
Okay, can you raise your right hand for me, please? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, thank you. You can place your hands down. Ms. Falk?
Yes, your honor. On counts 1, 2, and 3, state's recommendation is time served 26 days, credit for time served 13 days from June 27th, 2024 until today. We do ask the defense to stipulate to venue factual basis and identification for the purposes of this plea.
Stipulate.
Anything further, Mr. Ty?
Nothing further, and I understand that the FTA 24 FTA 000824 will be null pros.
That's my understanding.
Okay.
That is correct.
Mr. Riley, it's my understanding that in case 22 CR 004056H, you wish to plead guilty to equipment violation, possession of marijuana less than an ounce, and possession of an open alcohol container. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with your representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
No.
Okay, I'll accept the plea as negotiated, Mr. Riley. Good luck to you, sir.
Thank you.
I have that we still have position number 21.
Yeah, he's here. Come on, Mr. Hart.
And this is also going to be a waiver, is that right?
Yes, Your Honor, we're gonna waive arraignment. It's not guilty. He has a bond request if it's appropriate, because On the booking sheet, we see 2 probation holds. He says that is a mistaken identity. Those are not my probations. And so that leaves this remaining charge, whatever the bond is on that. He feels it'd be appropriate to ask for a signature bond.
Your Honor,
Okay,
can I get
so,
the position on that case real quick, just so I can pull up the
Yes.
jail screen?
Position 21, Frederick Hart.
And yes,
Well,
his name gets all misspelled all the time. It's Frederick Hart, H-A-R-T. H-A-R-T. He's in jail right now as C-A-R-T. Phonetically kind of sounds the same when you quickly say his name, Frederick Hart. Oh, they're telling me he is under H-A-R-T, correct spelling of last name. But he says, those probation things are not mine.
That's one of his aliens.
And he already, has he already got a signature bond on this case?
He does a pretrial services bond.
Right, so that's why I was saying, we're gonna ask for a bond reduction if appropriate, so it's already been done. So it's just not guilty in a waiver.
Okay.
Thank you. We're done. I think we're done on him. Yeah.
Okay, and who's representing Ms. McKnight on the DV bench warrant calendar?
Ms. Vigilante?
And have you had an opportunity to speak with her, Ms. Vigilante?
Yes, Your Honor.
Are you with us, Ms. McKnight? Joe McKnight.
Yes, I'm here.
Yes, good morning, Ms. McKnight. What are we doing this morning, Ms. Vigilante?
Your Honor, we'd like to request set aside of Ms. McKnight's bench warrant this morning.
Okay, Ms. Falk, did I take it that Ms. McKnight missed the court date?
That is correct, Your Honor. Let me just get to that case.
Okay.
And that's McKnight or Knight?
I think it's McKnight.
McKnight.
Okay.
It has to do with how frequent.
And this is the bench warrant bond forfeiture calendar. That's why I'm not seeing it. My apologies, Your Honor. I was like, where on earth are you guys getting this case? Just a moment, Your Honor. Let's see. Yes, that is just going really quickly to that one. It does look like it was a failure to appear before. Let me just. It was an FTA in Judge Porter's courtroom. There was the bond was forfeited on January 16th of 2024 for failure to appear at the plea and arraignment calendar. There was then a bond forfeiture calendar on June 28th, and then it was reset for this inquiry calendar on July 9th. So that's the history of the case that I see. He was released on a $2,000 signature bond through pretrial services back in September of 2022. And so I'm not sure what the basis is for failing to appear for court. There is no return notice or anything that would alert the state to any kind of address change unless he failed to file it.
Okay. Ms. Vigilante?
Yes, Your Honor. So Ms. McKnight, had been keeping up with her pretrial officer. She moved in December of 2023, and that really is the core of the issue here. She didn't think to update her address because she'd been in email communication with her pretrial services officer. But she did not receive that notice that was sent at the end of December to the 3380 Peachtree address. I'm not sure why it wasn't returned to sender, but she didn't receive it. She didn't live there anymore. She realized she missed court when her pretrial officer sent her an email. She got it about 3 days after that court date. After that, she did, reach out and they told her that she was going to be scheduled for another court date on June 28th. And however, she still had not updated her mailing address at that time. So even for that hearing, she knew she had a hearing on June 28th, but she didn't get that full notice. You usually get with exactly where to go and what to do. So she did show up to Prior Street on June 28th for that subsequent hearing. And you can see that the document where she updated her information and got this court date is dated June 28th. She was at the courthouse on June 28th, but she had sort of like a long kind of 90-minute ordeal where she was sent to one courtroom and then another courtroom, and she was sitting for a few minutes in each place, before people realized she was in the wrong place and were sending her elsewhere. Ultimately, that day she was sent to the clerk because by the time she figured out where she needed to be, she had missed that hearing. And so, like I said, there is documentation of that June 28th. She was there at the courthouse on June 28th when she was supposed to be. She just didn't make the hearing. I understand, Your Honor, she did do a pretty imperfect job here of keeping up with court, but it wasn't for lack of trying. The address she updated the court with on June 28th is accurate. There's also a phone number there. We did talk yesterday about, hey, your mailing address is what's really critical here. That's how you get all the information you need, what the courtroom is, all those details. And, we really can't rely on pretrial service officers for a phone call or something like that. We have to stay updated with the court. I don't think we have any issue with this happening again. It sounds like her housing is very stable. She is a single mom of 2 kids. She has a 2-year-old and a 7-year-old. She has them full time. She works at Wendy's. She's worked there since December. She also teaches weekly dance classes at her church. She has sort of a lot to lose by, being taken to jail on this. She does have a defense of others defense in this case that she would like an opportunity to present to the court. And, coming to jail with 2 kids and at risk of losing your job and everything else, I mean, it would really, really significantly impact her life. I don't think that there's any concern of any danger to the complaining witness. It's my understanding that that's why we have these inquiries. The complaining witness is her mother's boyfriend. I don't even think they're still together anymore, but even if they are, she doesn't live there. She doesn't live with them. She has her own place and has her own stability with her job and her kids. So I think I know Ms. McKnight has made some mistakes, but I think she's on fully understanding what needs to be done now, showing up for that next court date and getting this taken care of.
All right, Ms. Minaj, it's your responsibility to not only keep up with the court, but to make sure that if you move, that you inform the court of your new address. Now, I understand Ms. Vigiletti's advocacy for you, but had you gotten pulled over, you would have been arrested. And you would have had to make arrangements for your children and things like that. So you need to be more responsible and more and make sure that you keep in touch with the court. It's I allow you to miss court on one occasion, so you're using up your one occasion at this point in time. I'll set aside this warrant, but if you miss court again and it comes back before me, I won't set it aside a second time. You understand?
Understood.
All right, very good. Good luck to you, Ms. McKnight.
Thank you so much.
You're welcome. We'll prepare that, Ms. Vigiletti. Let's see, I believe that completes the calendars for this morning. Is that right?
I believe so.
Ms. Strong, whenever you're ready.
Position number 1 and 2 are reset for next Tuesday's SAP calendar, 7/16. Position number 3 was a negotiated plea. Position number 4 was waived arraignment, reset jail jury. Position number 5 was reset for trial. Position number 6 was a $1,500 signature bond through pretrial, level 2 amended bond. Position number 7 was reset for trial. Position number 8, 9, 10 were a negotiated plea. I don't remember what we said about Mr. Carroll. I know we were coming back. Are we resetting him or position?
There's a waiver and I
had
have.
bond hearing and the court ruled on it, so he's a waiver on his not guilty on his arraignment.
Position number 12 was a negotiated plea. Position number 13 was null pros. 14 was a negotiated plea. 15 was reset for next Tuesday's SAP calendar for a conflict attorney. Position number 16 was reset for July the 23rd SAP calendar. So was position number 17. Position number 18 was reset for 7/16. 19 and 20 also reset for 7/16. Position 21 was waived arraignment, reset jail jury. Position number 22 was a negotiated plea. And Judge, if you could give me the conditions on Mr. Hendricks before I continue, please.
I've got, do you need 12 months to serve 90 days, credit for time served 39 days, balance probated, no further contact with Ms. Burke, stay away from the Dolly Avenue address, mental health evaluation and treatment if necessary, and a permanent protective order that Ms. Falk was gonna get for you.
I just wanted to make sure I had everything. Thank you.
Okay.
The position number 23 is reset for 7/16 SAP. 24 reset for 7/16. 25 is also reset for 7/16. 26, I have that the defendant received an amended bond by Judge Edie. Correct?
Yes.
Yes.
27 and 28 were released. 29, 30, 31, and 32 are reset for SAP 7/16 for Ms. McLeod. 33 and 34 also reset for 7/16. What did we say about Mr. Murray? I know we were talking about the pad.
He
but-
had an amendment bond that I believe Ms. Vigilante is going to prepare.
What was the amended bond amount?
It was,
I believe-
I think it was just changing the good bond to a signature bond with all the conditions. Is that right?
Yes,
Yes,
that is
Your Honor, so
correct.
that would be $2,000 signature bond.
Thank you.
Through pretrial services.
Okay, thank you. 36 and 37 are reset for SAP 7/16 for Ms. McLeod. 38 is also reset for 7/16. 39 was a negotiated plea. 40 was null pros. 41 reset for Thursday's SAP calendar. 42 was waived arraignment, reset jail jury. 43 was a plea. And 44 was waived arraignment, reset jail jury. And the bench warrant calendar, the bench warrant was set aside. Anything I missed? Anything I need to update?
Judge, this is Ms. Lewis for update. Ms. McLeod is aware of the conflict, so she had filed an entry on some of those already, so that we were questioning about if they didn't have one assigned.
Okay. Anything further this morning? Yes, Ms. Strong.
Ms. Falk, Mr. Riley's, I think that's, no, pros, please.
Yep, I was just about to ask you which one I still owed you because I saw that I was still missing one. Thank you.
Yes, Daryl Riley.
I
Thank you.
appreciate it. Thank you.
Okay, if nothing else, I'll see you all on Thursday.
Thank you.
Thank you, Your Honor.
Have a good rest of your day.